ಮೂರ್ನಾಲ್ಕು ಸಲ ಮೂವ್ ಮಾಡಿದ್ದೀವಿ ಸರ್. ಮೂರ್ನಾಲ್ಕು ಸಲ ಮೂವ್ ಮಾಡಿದ್ದೀವಿ, ಲಿಸ್ಟೇ ಆಗ್ತಾ ಇಲ್ಲ. ಸರ್ ಇವತ್ತಿನ ಕಳಿಸ್ಕೊಡ್ತೀರಾ? ನಾವು ಹೋಗಂತ ಮೂವ್ ಇದು ಮಾಡ್ಬೋದಾ, ಫಾಲೋ ಅಪ್ ಮಾಡ್ಬೋದಾ? ಅಲ್ಲ ಇವತ್ತಿಂದ ಹೋಗುತ್ತಲ್ವಾ, ಅಂದ್ರೆ ಡೇಟ್ ಯಾವತ್ತು ಕೊಡ್ತೀರಾ ಏನು ಅಂತ. ನೆಕ್ಸ್ಟ್ ಹಾಗೆ ನಾನು ಇವತ್ತೊಂದ್ಸಲ ಮಾತಾಡ್ಬಿಟ್ಟು ಮತ್ತೆ ಸ್ಯಾಟರ್ಡೇನೂ ಹೋಗ್ತೀವಿ. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
Monday but you only okay, I'll go then on Bar Courtly held up morning session throughout I was here. 45 today. Monday case I could not appear. Again, the submission but dismissal. Okay. Thank you. Bar Courtly held up okay, I could not submit. So for not more than 45. Okay. Morning. Okay. Much obliged, madam.
Appear for
I appear for the
respondent.
petition. But the application, the orders, my lord, I appear for the defendant, the suit for injunction. The suit for injunction filed by the other side, respondent plaintiff. I filed my written statement, there is a delay in filing the written statement. My lord, there is 74 days delay from the date of filing the wakalat. 129 days delay from the date of service of summons. 129 days from the date of service of summons.
Permit me.
My lord, the affidavit, my lord, is at page, my lord, 62. Paragraph 4, my lord. I state that the reason for filing the written delay in filing the written statement was due to the hindrance in procuring certain documents in support of my case. I state that the said documents are necessary for adjudication of the case and hence I required some time. Lord, what has happened? Neighboring. Lord, I made an application permitting me to file the written statement. The application is filed for recalling of that order and permitting me to file the written statement. Paragraph 61. Paragraph 61. Pray that this honorable court be pleased to recall the order dated so and so and permit the defendant to file written statement. 61, the application. That order is passed on 30/10/2019. 30/10/2019. 30th of 18/3/20. Page number 62, my lord. Paragraph 4 I have said.
No, from the date that order is passed, when is that order passed? What has happened on that day? We are recalling an order dated so even not for the reason not by the statement, but for the order. What has happened on that?
That the reason is not that there are. That's what the documents that were this thing. I did not have documents of the plaintiff. The plaintiff's my lord, there are two plots neighboring. Her plot has a number, same number with a capital A. As present.
So not even one day for not what has happened. You don't even take that date also. And this is not doesn't it show that there are no qualified for the part of the defendant is not doing the.
My lord, in fact, there is another suit filed by me. That suit, that is the issue, my lord. The problem is there are two sites which are adjoining according to them. The numbers are, my lord, just a difference of A, one capital A. I am not able to get documents with regard to that property, the property that they are claiming. There is a confusion between which my property and their property, the identity itself. I was not able to obtain documents regarding that. Therefore, there is a delay. And my lord, the case has. Well, that is why, for me to obtain the documents with regard to those property. But as a practice, my lord, in Bangalore, these kind of applications are filed, seeking recall of the order as well as for seeking permission to file it. Yeah. Order, my lord, page 14. Page 13 and 14.
Court had dismissed your petition because it do not contain any reasons. Is it not?
My lord,
Because it do not contain any reasons, it is dismissed.
it has, they say, the trial court says, my lord, that what documents I had to file has not been detailed, therefore it has.
That's what a valid reason. Just say, simply saying that I have to procure. When the CPC stipulates that within a particular time you have to file, at least a valid reason. If these kind of reasons are considered and everybody is permitted to file applications, then it would defeat the purpose and purport of the procedure itself.
My submission is now lenient view may be taken. The case. has
On
not-
cost, how much?
I leave it to my lord.
Yes, come.
And
Reasonable cost.
Yes.
my submission, Your Honor, right, they are likely.
No, then a stay is obtained in this. There is a stay in this.
There was a status quo in their favor.
No, in this.
Stay is up.
Huh?
Stay is upright. There is a stay of the.
Say the
No, a
proceedings.
suit of the plaintiff, which is of 2018, for you not filing the written statement, and then a writ petition of 2022 till now, from the last 6 years, without you filing the written statement, the case is going on.
Similar, what has happened?
They are not filed even memo for posting also, Your Honor. I filed a memo for posting because what happened, Your Honor, two cases are there. First, I filed this case, Your Honor. Laterly, they filed in the Mayo Hall Court, and I filed a miscellaneous petition for clubbing the application. It is came to the quota 10, Your Honor, 35. At that time, I filed the application for clubbing the matter. It is the written statement is rejected by the Honorable Court as at the belated stage. Then he is not moved a memo also, Your Honor. From 2020, it is I'm suffering, Your Honor.
Well, in
The
fact,
present
this
writ petition
order has
is,
been passed in 2022.
the present writ petition is filed. Agreed with the orders passed in. What is this IA? Yes. Any IA or not there? It's all in Kannada.
IA under section 151 CPC.
Against order, the present writ petition is filed, questioning the order passed by the court below dated 3rd February 2022, whereby the court below had dismissed an IA filed by the defendant to recall the order dated. Where is your IA?
61, my lord. Order dated 30/10/2019.
To recall the order dated 30/10/2019 and permit the defendant to file the written statement in support of his case. The respondent herein, who is a plaintiff in the suit, had filed a suit for injunction and the court has granted an order of status quo.
Yes, Your Honor.
An order of status quo. The defendant, having appeared before the court and and summons the summons was served on the respondent, and after filing the wakalat, the written statement was not filed. Then the court, by order dated 30/10/2019, has treated the written statement as nil. And written statement as nil. Then in the month of March 2020, the present application came to be filed for recalling the order dated 30/10/2019. The affidavit in support of the IA, it is stated that the court has passed an order treating the written statement as null. The reasons for the delay in filing the written statement was due to the hindrance in procuring certain documents in support of the case. And the said documents are necessary for the proper adjudication of the case. Hence, he required some time to procure them and hand them over to the counsel to prepare the written statement. In spite of his best efforts, a delay has occurred. The same is not intended one, and for reasons beyond the control. And he has a good case on merits. He said the prayer is to recall the order and to file the leave of the court to file the written statement. The court below had dismissed the said IA by order impugned, wherein the court had observed that the defendant has not even failed to give the reasons or what are the documents that are required, and relying on a judgment. Is it a judgment of the apex court or this court, para 9?
Is the Supreme Court.
Relying on the judgment of the apex court, wherein the Honorable Apex Court has observed that it would be proper to encourage the belief in litigants that the imperative of Order 8 Rule 1 must be adhered to, and that only in rare and exceptional cases will the breach thereof will be condoned. Such an approach by courts alone can carry forward the legislative intent of avoiding delays, or at least in curtailing the delays in the disposal of the suits filed in courts, and accordingly dismiss the petition. Aggrieved thereby, the defendant placed before this court. Learned counsel appearing for the defendant submits that the court has the power to grant the time beyond 90 days for filing of the written statement. It is stated that the defendant has a genuine cause for not filing the written statement. The court, on technicalities, ought not to have dismissed the petition. It is stated that the plot of the petition, that the plaintiff and the defendant are adjoining plots, and the two suits are pending between the parties. Unless the defendant is permitted to file the written statement, it would cause a lot of hardship to the plaintiff, to the defendant. Next, learned counsel for the respondent plaintiff submits that the suit is filed in the year 2018. When the defendant has failed to file his written statement. And after this application, the IA is dismissed. He approached this court by filing this writ petition and obtained an interim order is granted, staying all further proceedings in the year 2022. From there on, the petitioner has not even taken any steps to pursue the matter or to get the matter disposed of. Learned counsel submits that all this conduct of the defendant speaks volumes about speaks volumes about how he wanted to protract the proceedings and to see that the said suit is not, that no orders are passed on merits in the said suit. And it is submitted that the court below had rightly dismissed the petition and no grounds are made out seeking interference with the said order passed by the court. Next. Having heard the learned counsels on either side, there is a material non-record. It is stated that there is a delay of 129 days from the from the date of summons and 74 days from the date of filing of the wakalat by the defendant in filing the written statement. The court on 13/10/2019 has treated the written statement as nil. And the present application came to be filed on 18/3/2020. This court has perused the affidavit as well as the order passed by the court, the trial court. The trial court was perfectly right in holding that there are no reasons stated for the said delay and dismissed the petition. It has become a practice that whatever is the procedure that is contemplated under the CPC, whenever the defendant feels that he'll come up with a written statement, and as a matter of practice, without mentioning the reasons, applications are filed. This case is one classic example where the defendant has taken it for granted that the permission would be granted without giving any reasons for the said delay. The purpose and purport for which a timeline is being framed would be defeated with these kind of petition. Whereas though as per the procedure, a particular time frame is fixed, still the court can condone the same or extend the time, provided the valid reasons are there, where considering the interest and balancing the interest of parties. And at the same time, that can't be granted for the sake of asking. A suit which is filed by the plaintiff for injunction in 2018, till now, till 2024, even after 6 years, without filing the written statement for various reasons, the suit is pending, which is mainly contributed by the defendant. Though this court feels that the reason on which the court had passed an order is a valid reason, but looking at the substantial interest of the parties, this court deems it appropriate to set aside the order and permit the defendant to file the written statement on the condition that he shall pay an amount of rupees 20,000 towards costs to the plaintiff within a period of 2 weeks from the date of receipt of the copy of the order.
One submission, my lord.
And the court below shall proceed with the suit and dispose of the same as expeditiously as possible, as this is a suit of 2018, without giving unnecessary adjournments. Yes.
One submission. The case is in 1/12/2024, my lord. Please give the short date.
Is that?
1/12/2014, 24 date is there in the trial court.
You file now taking this order,
matter.
file a petition for advancement.
Yes.
How can this court say, take the case on so and so date? It's for the trial court. Look, take this order and file an advancement
Both
petition.
the parties appear on such a date.
No. File an advancement petition, court will order. Yes.
That will be liberty may be permitted, Your Honor.
Sorry, all those court can't do it. Yes.
Otherwise, it will go to 112, my
You
lord.
can't ask for so many things. Yes.
Petitioner.
Yes. What is this order?
No, The
That is
present
a critical
petitioner is the
privilege.
father and the respondent is the daughter, my lord. She earlier filed a criminal miss petition 65 of 2011,
55 of?
65 of 2011. my lord.
Hmm.
In that, after inquiry, 1,500 per month was awarded to the
Huh?
daughter. 1,500 per month maintenance was awarded by the family court.
To the daughter.
Daughter.
What is the age of the daughter?
Now, as on this, as per annexure A, my lord, that is petition 164 of 19 when it was filed, she was aged 19 years, my lord.
19 years.
Thank you.
Hmm.
So agreed by the order of the family court, the daughter, she filed a revision before this honorable court and it is numbered as RPFC number 80 of 2012, my lord.
Hmm.
This honorable court enhanced from 1,500 to 2,500, my lord.
Hmm. Hmm.
Later, she filed criminal miss 272 of 18,
Hmm.
claiming the maintenance from the period 27/6/2016
Hmm.
to 27/6/2017.
20?
27/6/16 to 27/6/2017 for 12
At
months.
the rate of 2,500.
Please, my lord. Total for 30,000 per month, my lord.
Hmm.
Later, it was withdrawn by the respondent daughter and she filed a fresh petition claiming same maintenance for the same period. That is, in this petition, it is marked as annexure A, my lord. That is criminal miss 164 of 19, my lord. Now, later, my lord, the
No, 1 minute. No, she has filed this 272 of 18, criminal C miscellaneous 272 of 18, wherein she sought maintenance from 27/6/2016 to 27/6/2017 at 2,500.
please, my lord.
That was withdrawn.
Withdrawn with the liberty to file a fresh
then
petition and
what,
the court has permitted
uh,
to file a
uh,
fresh petition,
uh,
my lord.
Hmm.
Later, this present annexure A, that is CR miss 164 of 19,
Hmm.
filed for the same period, my lord.
Hmm. Amount?
Amount also 30,000, my lord. Same, that duration also same, my lord. It is produced at page number 8, running page, my lord. Annexure A, it is marked as annexure A, my lord.
Amount, how much she claimed?
30,000, my lord.
30,000?
30,000 for that 27/6/2016 to 27/6.
At what rate?
2,500 per month only. My lord,
So what did the court do?
we filed an objection that as per subsection 3 of section 125, the claim petition is not mentally liable, which was filed, the petition was filed in the 2019 and claiming that amount for the period.
Because that
16/7.
that is no longer the Supreme Court judgment is,
Please, my lord.
it's a continuous cause of action and there is no
Another
limitation
point is
for
that, my lord, another point, my lord, in this petition, my lord, when case counter allegation and there is a severe allegation are made in both the parties regarding the claim for the maintenance, my lord, the court has after taking the objection from the parties and rejoinder from the parties, my lord, posted for inquiry, my lord, on 12/2/2020. Running page 20 of my
No,
petition.
no, the present application is for recovery of the
Recovery,
money.
please, my lord.
No, what is relevant in that is, according to you, it's barred by limitation.
Barred by limitation. one-
That is no longer available, one. So the other ground which you are saying is not connected to this.
My lord, in running page 20, that is on dated 12/2/2020, the court has permitted to lead evidence, my lord. Order sheet dated 12/2/2020, my lord. After filing of our objection and also the documents, my lord, the court
So
has-
please come to the order straight away, we'll understand from the order.
it is page number 20, my lord.
Page number 20.
Running page 20.
Uh,
It is order sheet of the trial.
Heard, perused, no, the impugned order.
Impugned order is that it is at
My lord, the proceedings initiated under 125(3) has been sought for squashing of the proceedings, sir. Holding that, my lord, the claim made by the respondent is barred by, my lord, since it is barred,
So no order is passed.
no order is passed.
Right
The
away,
Because
same,
ground,
the same is covered by, my lord, order, passed in recently, my lord, in writ petition 10,449 of 2022. The same was dismissed, my lord, on 12/7 to 27/6, 2024. Yesterday only copy has been released, my lord. I will get it and I will.
no, but I remember that all. Yes.
the thing is, my lord, that the court, when the case has posted for
First
inquiry.
of all,
My lord,
look, first of all, you have questioned the proceedings to quash it because it's not maintainable. Only to that limited extent this court is concerned. Remaining things, whatever that happens, happens before the court. You can take care of it. You file an appropriate petition. If something is not considered, then you can come back. No, at
Without-
this stage, we'll not go to any other thing.
Please.
Please
The
come.
thing is, my lord, without providing an opportunity and also the.
No,
input order
there is no
last-
order that is impugned before this court, which this court will find fault or
Warrant.
do it whether legal or
By
not.
the our arrest warrant, we have challenged.
Where is the arrest warrant?
It was.
You
issued
saying
in-
that there is no order?
17/8/2021, since he
17/8/2021
failed to
was
comply, pay the amount, my lord, arrest warrant has been issued.
Hmm.
That issuance of arrest warrant has been called in question along with the petition.
Where is that order?
17
Page number 25.
24 and 25 is the typed copy.
25, order dated 17/8/2024, prayer of HNR is rejected, issue arrest warrant against the respondent, returnable by 29/9.
Something problem with the page numbers where I'm not able to see
Page
that.
number 25, continuation page number, my lord.
Typed copy, it is. 24 is the original copy, 17/8 to 21, it is in manual, right? 20. Last page of the.
Order dated 17/8/2021.
17/8,
21.
2021. Annexed ID, internal page 8.
17/8,
Ah.
2021. What is that?
Issuance of arrest warrant.
Prayer of HNR is rejected, issue arrest warrant
Against the
against the
respondent.
respondent.
Why?
Since he is unable to pay the amount, my lord, a warrant has been issued.
What is HNR?
That is the
Advocate,
council's name.
Counsel
initial
who is
name.
representing the petitioner.
In earlier proceedings, the previous proceedings.
Anyhow,
my lord,
That whatever you have to do before the court below. This execution petition is maintainable. Please come. Agreed with the order passed by the court below. Whereby the court issued arrest warrant. Arrest warrant dated 17/8/2021. The petitioner is before this court. The petitioner is the father and the respondent is the daughter. The earlier, when the daughter had filed C miscellaneous 65 of 2011, the court had granted an amount of rupees 1,500 per month as maintenance. Agreed thereby, she had filed RPFC number 80 of 2012, and this court had enhanced the amount from 1,500 to 2,500. Thereafter, she has filed the execution petition, that is 272 of 2018, seeking for recovery of the maintenance from 27/6/2016 to 27/6/2017. And she sought liberty to file another petition. Accordingly, the present petition C miscellaneous 164 of 2019 is filed. In that, as the petitioner father has failed to pay the amount, the court has issued the arrest warrant by order dated 17/8/2021. Then a counsel appearing for the petitioner submits that as per section 120,
5 subsection
125,
subsection 3.
subsection 3, the amount beyond 1 year cannot be recovered, and on that, no execution proceedings are maintainable. Whereas in this case, in 2019, she is seeking recovery of the amounts between 27/6/2016 and 27/6/2017, which is not maintainable. And the court below, without considering all these aspects, had issued a warrant. And the same is without, and the same is contrary to so and so. He submits that the execution proceedings itself are not maintainable. Learned counsel appearing for the respondent submits that in the light of the you have only taken that, let's say, citations regarding this. Just find out, ask her. In the light of the judgment of the Honorable Apex Court in case of so and so, where the Honorable Apex Court has held that it's a continuous cause of action, and it cannot be said that the amount of the arrears of maintenance cannot be recovered beyond 12 months. 12 months. In the light of the said order, the contention of the learned counsel for the petitioner has no legs to stand and has to fail. When once this court is of the view that the maintenance, beyond 12 months, and once this court finds no reasons to interfere with the order passed by the court below, accordingly dismissed. Yes, next. Yes.
Wife's petition, my lords. Wife's petition. In a, my lord, petition for divorce. Section 24 application was filed for maintenance. That has been dismissed on the sole ground that she is qualified. So therefore she can get a job and maintain herself.
When is the marriage?
My lord, the marriage took place in Mangalore on 25/4/2018.
When from, when the MC filed?
Pardon me, my lord.
When is the MC filed?
My lord, MC is filed in 2021, May 2021. After marriage, my lord, they went to Australia, both of them. Because wife was earlier working in Infosys. After marriage, my lord, she left the job and went with the husband to Australia and settled there. So there, my lord, she was pursuing her master's degree. So when she was pursuing her master's degree, differences cropped up, my lords, and then, my lord, the wife has filed a petition, my lord, in Mangalore for divorce in May 2021. Then, my lord, what has happened is the husband, even though aware of the petition filed by the wife for divorce, files a petition in Australia, my lord, seeking the relief of divorce. And there, my lord, even though an anti-suit injunction order is passed by the trial court, my lord, there he proceeds and gets an order, my lord, for which I had not consented, because even 2 years earlier on, I had filed this petition. So, my lord, he takes up all these grounds, saying that he had already filed a petition in Australia and divorce is granted there, that I have not sought for maintenance in the family court of Australia. And, my lord, I am educated and qualified, and therefore I can maintain myself. And, my lord, I have earned some money in, my lord, by doing internship, because I am a designer, both are software engineers.
So what's her qualification? She completed her master's.
She has now completed her master's. Earlier, my lord, she had not completed.
When did she complete her master's?
My lord, that must be in the year 2022, my lord.
Yes. No, the court has rightly held a lady who has completed her master's
Yes.
can't get the job to maintain herself.
My lord, true. My lord, qualification is there. She can get a job. But nevertheless, my lord, that cannot be a ground to deny me maintenance, because during that period, when, my lord,
Purpose of, the whole purpose of granting maintenance is what? Because the wife
to
was
maintain
not in a
herself.
position.
Yes,
And
Now-
because
now, my
she's
lord-
thrown out of the house for various reasons,
yes,
only to take care of that period of whatever
Yes.
requirement.
yes.
This is the purpose. And now she worked there and she is in a position to maintain herself. She is a postgraduate.
My lord, she became a postgraduate after
Have you
filing the
filed-
petition
have
for
you
divorce.
Have you filed the statement of assessment
Yes,
liability?
yes, it is filed.
Whatever is that. Let us
My lord,
please straight away come to the order.
The order, my lord, is at Annexure G.
Page number.
My lord, it starts at page 105. My lord, the relevant portion would be, my lord, paragraph 18 at page 120. The reasoning starts, my lord, from paragraph 8 itself. The contentions are noted.
So
Paragraph,
when this MC is filed, she's pursuing her
she
masters
was
in
pursuing her
Australia.
masters in Australia and they had separated. At that point of time, she did not have any income. So then, my lord, her father used to, my lord, send some money for her to sustain in Australia there. Because the cost of living, my lord, the cost of living is admitted by the husband. My lord, I have claimed, my lord, 2,000 Australian dollars as maintenance. The husband admits in his affidavit of assets and liabilities that the living expenses in Australia is $2,220 per month. So I have claimed reasonably about $2,000. So at least, my lord, from the date of the application that I have filed, till, my lord, even now, if we claim, my lord, I have got a job, date on which, my lord, I have got a job, and unless he proves that, my lord, to that extent, I am entitled for maintenance, my lord. My maintenance claim cannot be completely rejected on the ground that I am qualified and I am able to get a job. That, my lord, is directly covered by the judgment of the
Now,
Honorable Supreme
please
Court.
tell the court, what was the period where she was doing her masters?
My lord, from the date she went to Australia, my lord,
It can't be for.
that is in 2018 itself.
Then when she completed, it is 2 years, 3, how can it be 3 years?
It is, my lord, I do not know, my lord, the software engineering, the masters in software engineering. I really do not know, my lord, the
So
extent of the
generally, all
course.
masters are of 2 years.
Yes, 2 or 3 years, maybe, my lord.
Hmm.
Maybe after 1 year, she has joined there. After going to Australia, maybe after 1 year. But
No, MC is filed in the year 2021.
MC is filed in the year May 2021.
May 2021.
Yes,
She completed in?
my lord, must be about
Must have
2000
completed in the same time.
in 2022, my lord.
It is 4 years.
No,
If it
Lord,
is from 18 to 22,
my
it's
lord,
4
she
years.
must, my lord, immediately after going to Australia, she did not take up the masters.
Please get those particulars. I
Very,
will
very
prepare.
well.
Post this matter on 16th. By the time then counsel for the petition shall get specific instructions with regard to the masters and when she has joined and completed.
Very well. Interim order may be extended till next.
Interim order is extended till then.
16th.
Yes,
16th.
yes.
Hearing for the respondent in this case.
Where is the counsel for the petitioner? This is a writ petition of 2019. Give the docket. No representation for the petitioner. Post this matter tomorrow as part heard.
Day after, kindly have it, and day after tomorrow.
Day after tomorrow, it is not possible. Post this matter on Monday.
And
The caption part heard the counsel for the respondent in part and no representation for the petitioner.
the name of, I have filed an NOC Wakalat, my lord. My name is not shown in the past title.
Give
Maybe.
your name.
Yes.
It is submitted that so and so as filed wakalat for the respondent. This fee is directed to print the name of so and so. No, post this matter not part heard. Post no representation for the petitioner. Counsel for the respondent is present. Post for dismissal on the top of the list.
Madam.
Yes. Next matter.
I'm for respondent in serial number 6, not for 6.1. My learned senior is appearing through VC for
I
6.1.
appear for respondent in serial number 6, my lord.
Yes. You're for the petitioner.
I'm for the petition.
What is the suit for?
Oh, this is declared a particular release deed as void. Now, in a connected suit, that issue was framed and decided against the plaintiff.
You're the plaintiff,
I'm the defendant.
defendant in the suit.
So we succeeded in a connected suit where the same release deed has been upheld. Where all of us are parties to that suit.
What is the suit number?
My lord, it is there. So the issue before my lord here is under Article 227. In view of the finding on a fact, on an issue of the validity of the release deed having come in our favor and that judgment having attained finality, it was not challenged before this court. We raised the issue of res judicata because everything in this suit depends on the release deed. So we made one mistake in the sense, first we filed an Order 7 Rule 11 for rejection when obviously a res judicata plea cannot be decided at that stage because we have to look beyond the plain pleadings and essentially the pleadings and the issue of the other previous suit where it was decided. So therefore, we filed an application to treat it as a preliminary issue as to the maintainability on the issue of res judicata. Now, my lord will see the impugned order at page number.
I think there are two writ petitions. What are the two IAs?
Two suits.
Two suits.
Lord will see page
Where is the order?
Page 19 is the order.
Both are clubbed together. Both the
Suits are
suits
not clubbed.
They're not clubbed together, but parties are claiming under each other. Common parties.
So this is OS number 3423.
That's right.
The parties are not common, my lord.
Huh?
It is only the petitioner who is common.
Huh.
We are separate.
OS
No, what I-
3423,
Ah.
he is a defendant in the suit.
Yes, please.
Yes.
Now, my lord, how the court has decided, kindly come to page number 23, the manuscript page number 23, 22. Para 9.
No, let's understand the facts also. Let's read from the beginning.
Kindly see para 2 at page number 20.
Yes.
The counsel for defendants 2, 3, and 5, in his memo of facts annexed to application, stated that the issues arose substantially deals with the adjudication of earlier suit OS number 1566 of 2007, which was filed by the plaintiffs against the defendants.
Now, this suit, OS number 1566 of 2007,
Yeah.
filed by whom?
By myself.
Filed by the very same plaintiffs
Yes.
against you.
Yes.
Plaintiff and one other person, my brother, together we filed 1566.
Yes. Yes, please proceed.
The said suit came to be dismissed on 7/11/2015. And hence this suit is a gross abuse of the process of law. Therefore, the issue number 2 framed may kindly be treated as a preliminary issue by allowing the application. Accordingly, the counsel for defendants 2, 3, and 5 prayed to allow the application. My lord, the issue of res judicata was framed as issue number 2. We only sought that it be treated as a preliminary issue. And per contra, the plaintiff resisted the application and raised the objections contending inter alia that the application is not maintainable. This court, while disposing of an application filed under Order 7 Rule 11, held that the question of res judicata is a mixed question of law and facts. And the defendant not having challenged the said order, a mixed question of law and facts cannot be treated as a preliminary issue. Defendants 2, 3, and 5 filed the application only to cause delay and to protract the proceedings. And the defendants are re-urging the contentions which they urged in the earlier application. Defendants filed the application only to harass, etc., etc. Therefore, the same is liable to be dismissed. Then, my lord, the reasoning of the court, Lord will find at page 22, where from paragraph 8 onwards,
Yes.
the plea of res judicata is recorded. In para 9, the defense of the plaintiff that the plea of res judicata is a mixed question of law and fact. And issue number 2 deals with a matter of res judicata, and hence evidence is necessary to determine the said issue. Therefore, it is not possible to treat the issue number 2 as preliminary issue. That is the contention of the plaintiff. Then he extracts provisions of Order 14 Rule 2 CPC at page number 23. And kindly come to para 11 at page 24. He relies upon a judgment of reported in 2021, volume 9, SEC 99. And then in para 12, the counsel for plaintiff argued that the question of res judicata is a mixed question of law and fact. Therefore, there is no need to treat issue number 2 as a preliminary issue. He further also argued the court, while disposing an earlier application, held that res judicata is a mixed question of law and fact and hence warrants evidence. Then kindly see para 13. It is true that this court, while disposing of IA number
Please come to para 14. What exactly is the court meant by this?
in this
para
case
14?
also, this court is disposing of IA number 4. Observed that the principle of res judicata is a mixed question of law and fact, which warrants evidence. As per the provisions of Order 14 Rule 2 CPC, the issues which only deals with question of law and which touches the matter of jurisdiction of the court requires to be treated as preliminary issues and not other issues. Therefore, treating of issue number 2 as preliminary issue is not possible. My lord, res judicata, I will have due respect to the court. Res judicata, the conclusion of the court that res judicata can never be treated as a preliminary issue is my respectful submission. The court misdirected itself,
Yes.
right? My lord, there was no application of mine as to whether there is a mixed question of law and fact. The conclusion of the court on the basis that a res judicata can never be treated as a preliminary issue is unfortunately wrong. It is our respectful submission, my lord, that this is a fit case where running a trial would be vexing the court unnecessarily after the matter has reached finality in a connected suit. It was fought over close to 2 decades and has reached finality over there. So, my lord, in the face of a judgment and decree upholding my release deed, these suits, which essentially challenge the very same release deed, will not lie. There is nothing, the court did not apply its mind whether any evidence is at all is required. On the basis of pleadings, on a mere comparison of the issues framed in that suit, the judgment, the pleadings in that suit and this suit, which is undisputed, without any further evidence, the matter can be treated as a preliminary issue is our only contention.
Yes.
My lord will see issue number 2 is already there
Yes.
as the plea of res judicata is raised. The only defect is the learned judge wants to treat it as a regular issue, not as a preliminary issue, which means we have to run through the rigmarole of another trial between the same parties when an issue has reached finality in a previous round of litigation. What we say, my lord,
What is that attained finality in the earlier round?
yes, my lord, we have produced the judgment and the plaint in the earlier suit since my lord, we have produced it since my lord has posed this question and we anticipated this from the court. This exercise, my lord, I'll take my lord through since my lord has very rightly asked the question, I'll take my lord through the pleadings in the earlier suit and the judgment.
This is who's for partition earlier suit.
No, a declaration that the release deed is void.
Relief is also same. Let's look at the.
Same property.
Let us look at is it there?
Yes, we've filed the
Let's see
memo.
the plaint in OS number 15.
Yes, we produced the plaint, we produced the release deed, we produced the judgment as well.
Hmm.
I'll take my lord through all that. But my lord, I'll take that and I'll obviously submit to the court. But isn't that an exercise which the trial court ought to have done?
No, that is true. We'll go
Right,
to that
right,
later. Please
right.
point out that.
Yes. What we have done is, we have filed a memorandum, my lord,
Yes.
on 21st October 22.
Yes.
My lord has that production of documents by the petitioner. It's a compilation filed on 21st October 22. A separate compilation.
21st.
My lord has it.
Yes.
Petition and notes.
I have not received this separate complaint.
Sorry?
This is a suit for
compilation, not
cancellation of release deed.
Yes. You okay? Can I proceed?
Only the first initial I've received. Directly that compilation not received.
The plaint, the plaint.
I have the plaint in 1556.
Yeah, same thing.
Plaint and judgment.
Yes, sir. I'm not saying anything.
Yes, this is, look at the cause title, SS Pandit. You're representing him.
SS Pandit is my brother. I'm not representing him in this suit.
Hmm.
Shamla Venkatadri is my party in this suit. In the
Who is
present-
she? What is the relation between?
Brother and sister.
My brother and
Brother and
sister.
sister. Then the defendants,
We are the defendant.
Difference, Chetan Pandit
you
is,
represent
I
them,
represent.
both of them.
Yes, yes.
Hmm. Then the suit.
And remember.
In the other suit, my lord,
1 minute. One
in the other suit, he was not a party at all in the earlier suit.
Yes.
What my learned friend said, that we are parties in the other suit is not correct.
No, the defendants are Chetan S. Pandit, V.S. Pandit.
1566 of 2007.
Yes, I'm looking at it.
My lord,
No,
turn the
what-
page, kindly turn the page, my lord.
No, 1 minute. No, who are the petitioners in this? Lakshmi Vijay Kumar, Ravi S.V. Pandit.
They are the LRs of VS Pandit.
Yes.
Ravi S.
Yeah, we are the contesting defendants.
Lakshmi Vijay.
Yes, yes. The first
They are
two,
parties. They are parties to the suit,
Now, in the other 6.1, the connected
No.
matter.
or in which he is appearing.
He's appearing for 6.1.
handle
We
one
are
at-
not,
Ah.
myself and respondent of 6.1, we are not connected. at
Yes.
all.
my lord, to avoid confusion, we'll handle one at a time. I mean, there are two matters, otherwise it can be confusing, my lord.
No, we are dealing with first point. Yes,
I'm grateful.
yes. So first, the suit is cancellation of release date.
Yes, please.
You are a party.
I'm a party, my lord. In
Ah.
fact, we were the contesting defendants. The first two are not the contesting defendants. I mean, first.
Only first one is not contesting.
No, please come to the finding in this.
If everybody starts interfering, then you all can support me.
Yes, where is that?
So, my lord, first of all, the plaintiff, my lord, will find at page number plaintiff prayers. Is it? At page number 47. 47.
Yes.
Wherefore the plaintiffs pray for a judgment and decree for cancellation of the release deed dated 8th December 2003, registered as so and so before the sub-registrar Gandhinagar, Bangalore, and the same be delivered up and then the jurisdictional sub-registrar be directed to make an entry about the cancellation. So this is the prayer in that suit. Essentially assailing the release deed. Right,
Please
my lord?
come to the judgment. I've
Yes,
seen
and
that.
then my lord will see, before my lord had a look at the prayer, for a meaningful understanding of what the prayer is, my lord will see at page 50 is the release deed.
Please.
50 is the release deed, which was under challenge. 50.
Hmm.
And my lord, for easy understanding, my lord will come straight away to the sketch attached at page 62.
Yes.
And my lord will see, I hope it's legible, my lord. It's clear? Yes. My lord will see Schedule B, Schedule C, and Schedule A. Schedule B and Schedule C have been released in favor of our clients.
Schedule?
B and C. Schedule A is retained by them. As per this document.
Yes.
And my lord will see why this is done. I mean, I'm not just for the understanding of the court. These are marginal land to the main property, which my lord will find 40/B and 41. My lord see this larger property below, 40/B and 41. 40/B belongs to us, 41 belongs to them. These are marginal lands, which was acquired subsequently. And there was the Bangalore Development Authority had a policy where there are marginal land which is of no use to the BDA.
Yes.
The offer to be made to the main property holders. I mean, because it is of more.
Yes, I understand.
Yeah.
Yes.
So
yes.
therefore, my lord, B and C, by an understanding in terms of the release deed, came to us. And this release deed was under challenge, and the release deed has been upheld.
Hmm.
And my lord, very crucially, the judgment, my lord will find. First issue, since we are talking about res judicata, my lord will go to page 8 of the judgment.
Yes.
8. My lord has issues there. I hope we are on the same page.
Yes.
And my lord will see issue number 3,
Yes.
whether the second defendant, that is us,
Yes.
proves the suit is barred by the principles of estoppel, acquiescence, abandonment, and waiver.
Yes.
And finally, see issue 4, whether the plaintiffs prove that the release deed executed by the first defendant in favor of the second defendant is not binding on them and is liable to be cancelled. And my lord will find the findings at paragraph 8 on those issues raised by the court. On issue number 3, my lord, the court has held in the affirmative as against the plaintiffs. And on issue number 4, in the negative, upholding the release deed.
Yes.
So my lord has findings on those issues.
So please come to the present plaint.
Yes. And my lord, the counsel who appeared for the plaintiffs in that suit is the same counsel appearing for the plaintiff in this suit.
Let us see the plaint.
Yes. My lord will find the plaint at page number 27.
Yes.
Now, the issue, my lord, is this, I mean, where they take shelter to escape the judgment. I'll point that out.
Yes.
My lord will see that this suit was filed
Yes.
after having lost that suit. The plaintiff here who was a defendant there, instituted this suit after having suffered the judgment and decree.
Yes.
And in paragraph 12, they hinge upon an observation. Kindly see paragraph 12 of the plaint.
I've seen that.
And my
Yes.
lord, let me take my lord back to the judgment
Yes.
and the plaint. It doesn't say that the plaintiff was entitled to re-agitate for a second run to question the release deed.
So this is a suit for partition.
In respect of the very same properties in which she was a party challenging the release deed.
Yes.
And she takes shelter in the observation, my lord, which is misquoted.
There are two properties.
B and C, as I showed, my lord, B and C comes to us in the release deed.
A,
A goes to them. There is no dispute as far as A is concerned.
yes.
And A is jointly held by brother and sister who joined together in challenging the release deed.
Who appears for the respondents in this? Notices are served.
Yes, yes.
Rajaditya Sadasiva.
Yes, yes, my
I'm
friend,
appearing for,
friend is here.
for respondent number 1, I'm appearing. ma'am.
Yes, what do you say?
I-
Yes,
Can I rejoin then, you know, in 10 minutes?
yes,
I'll reserve 10 minutes for rejoinder after my friend finishes.
yes.
My humble submission is we are not on the merits of res judicata or whether my suit is barred by res judicata. The question of res judicata is still left open for my learned friend to.
Why it cannot be
Agitate.
decided as a preliminary issue?
As a preliminary issue, the law is very well settled that if any issue requires even an iota of evidence, then it cannot be treated as a preliminary issue. It has to be treated along with other issues. Preliminary issue is only where without any evidence, like jurisdiction of the court, does not require any evidence. Those matters, the suit itself can be disposed of completely without any evidence. Only such issues can be treated as
No,
preliminary issue.
the
That is a very
purpose
well
of-
established.
The purpose of treating it as a preliminary issue is once the issue of res judicata is decided.
This requires trial. And it is not only this suit, there are 3 previous suits which the petitioner, the
When the suit
husband of
is-
the petitioner
when-
had filed.
When a suit is.
Which was dismissed for
When an
fraud.
application is filed under order 7/11 CPC, where it is questioned on the ground of limitation, barred by limitation. Limitation is a question of fact and law.
Correct.
In those cases, there are several judgments of the Honorable Apex Court where it is said that the said issue of limitation has to be dealt with as a preliminary issue.
Correct.
Where it involves question of law and fact.
Only law, not fact.
No,
If it
so-
requires a disputed fact
Hmm.
and evidence is required, there cannot be a preliminary issue.
Yes.
If it is pure question of law and no evidence at all is required, that can be treated as a preliminary issue.
Hmm.
That is a very well established citation. I'll take a lot of trips through the citation
Yes.
subsequently. In this, they had admittedly filed an application under 7/11 to reject the suit on the grounds of
So
res
that I
judicata.
understood. That was
The
dismissed.
honorable court has already held that res judicata is a question of fact. It requires evidence. This order has not been challenged. It has attained finality. This would operate as res judicata on them because the trial court has already held that this would require trial. Now, once the trial court has held that it requires trial, the trial court cannot hold it as a preliminary issue because the law itself of Honorable Supreme Court says that anything that requires any evidence cannot be treated as a preliminary issue. So the trial court is barred by its own judgment, its own order, and the petition is also barred by res judicata as far as that order is concerned, because
Yes.
that order was never challenged. So the short question is, can a question of res judicata be treated as preliminary issue after the trial court has already made a finding that trial is required? The answer would be no. If the lordship were to indulge us into the merits of res judicata, then
That
it does
will
not.
not go. Just for the understanding of the code, I'm looking at it. This court
Yes,
will not.
The
decide on
understanding
it.
of the court, the order of the trial court of the earlier order, that I think it has already been produced. In any case, I'll produce it one more time. This is the orders of the trial court in,
No, we'll take it that the court had dismissed that order 7/11 petition.
yes,
Hmm.
holding that res judicata requires trial. Now, once that has been held, a subsequent application to overcome that would also be barred by res judicata. Now, this application that is currently being filed would require the court to overcome the earlier order.
Yes.
which is not possible. It has not been challenged, and therefore it is binding upon the court as well as the parties. In that order, Your Lordship would kindly see
Where is that finding?
the finding is at para 12, Your Honor. Your Lordship has para 12.
Yes.
The plaintiff denied her rights in the scheduled property were determined in suit 1566 of 2007, difference 2, 3, and 5, contending that already the claim of the plaintiff in scheduled property decided, and hence plaintiff is not having any cause of action to file the present suit. Indirectly, difference 2, 3, and 5, contending that the suit of the plaintiff is hit by a principle of res judicata, but it is pertinent to note that the question of application of principle res judicata is a mixed question of law and facts, which warrants evidence. At present, there is no any evidence on record to conclude that the suit of the plaintiff will be hit by principles of laid down by Order 2, Rule 2, or the principles of res judicata. Only after collecting evidence, the said factor can be decided.
Yes.
Hence, at the present, the plaintiff is not liable to petition.
Yes.
Having held that it requires evidence, this order has not been challenged. Now, this order has attained finality.
Yes.
Now, to overcome this, a fresh application is filed to treat it as a preliminary issue. That is not possible because the Honorable Higher Supreme Court has already held. I will pass on the judgment. As far as preliminary issues are concerned, in this
Yes.
citation, page number 9, just above para 13. End of para 12, just above para 13.
From para 11, 12, read para.
Para 12, my lord.
Yes.
Sub-rule 2 of Order 14, Rule 2 CPC says, lays down that where issues both of law and of fact arise in the same suit, and the court is of the opinion that the case or any part thereof may be disposed of on an issue of law only, it may try that issue first, if that issue relates to A, the jurisdiction of the court, B, a bar to the suit created by any law for the time being in force. The provisions of this rule came up for consideration before this court in so and so, so and so. The relevant portion is extracted. Under Order 14, Rule 2, where issues of law, of both of law and of fact arise in the same suit, and the court is of the opinion that the case or any part thereof may be disposed of on the issue of law only, it shall try those issues first, and for that purpose may, if it thinks fit, postpone the settlement of issues of fact until after the issues of law have been determined. The jurisdiction to try issues of law apart from the issues of fact may be exercised only where, in the opinion of the court, the whole suit may be disposed of on the issues of law alone. But the court confers no jurisdiction upon the court to try a suit on mixed issues of law and fact as preliminary issues. Normally, all the issues in a suit should be tried by the court. Not to do so, especially when the decision on issues even of law depends upon the decision of issues of fact, would result in a lopsided trial of the suit. Though there has been a slight amendment in the language of 14 Rule 2 CPC by the Amendment Act of 76, but the principle enunciated in the above quoted decision still holds good. and there can be no departure from the principle that the court confers no jurisdiction upon the court to try a suit on mixed question of law and fact as a preliminary issue, and where the decision on issue of law depends upon decision of fact, it cannot be tried as a preliminary issue.
Yes.
Now, the court would be barred by its own orders in the previous matter, where the court has already held that issue of res judicata requires trial. Should your lordship indulge us into the actual merits of res judicata, then that would require a very detailed argument, because it is not just the previous suit. We have been litigating for over 40 years. There are 4 different suits, 2 partition suits which they themselves have filed and they have failed. Now, to take your lordship through all of it would require a lot of time, which is outside the scope of this.
That's not required. Yes.
An application was erroneously made, as I said, at the Order 7, Rule 11, to agitate an issue of res judicata. It was a mistake, because the plaint, in an Order 7, Rule 11 application, only the plaint averments could be seen. Even the pleadings of the earlier suit, even if produced by us, could not be seen because of the embargo under Order 7, Rule 11. And necessarily, a plea of res judicata can never form subject matter of an Order 7, Rule 11 application. Therefore, the court was right in rejecting that application on those grounds. And my lord, a passing reference that an issue of res judicata is a matter for consideration at trial is accepted. But to take that to an extreme situation, that every issue of res judicata necessarily involves a mixed question of law and fact, is stretching it beyond what the law prescribes, is my respectful submission. And therefore, to raise a plea of res judicata on that count does not arise, because the scope of Order 7, Rule 11 is very different. We accepted that judgment as right, and then we filed our defense. We produced the pleadings in the earlier suit. We produced the issues, the judgment, the release deed, and no disputed question of fact. On a question of law, we requested the court to frame the issue as a preliminary issue. There's nothing more to be seen except the documents already on record, and the court will arrive at a conclusion. The preliminary issue can be decided one way or the other without any further evidence. My lord will see, I'm not for a moment saying that I will succeed. All I'm saying is the court should apply its mind and come to the conclusion whether this is a rerun of a matter already settled and reached finality, and whether the court is being vexed all over again unnecessarily is the only plea. And in deciding that, in our respectful submission, no further evidence is required. All on admitted. Whatever documents I demonstrated before, my lord, today, is the very same documents which I will be demonstrating before the trial judge for him to take an opinion as to whether the suit is barred by res judicata. No further evidence is required. And in fact, in their own plaint, they refer to the judgment, and in their plea, kindly see para 12 of the plaint, they take the stand that that judgment is not binding on them because of certain observations made in that judgment. And we will clarify to the court. Therefore, no further evidence is required. It's a call which the judge will take on interpreting that observation of the trial court. He will then consider the issues which possibly arise here without any further evidence on record. My lord, therefore, this is a case. And my lord, the court has gone, while dismissing the Order 7, Rule 11 application, in passing it has said that a matter of res judicata should be decided in trial. It is right. But to conclude that every issue of res judicata necessarily involves a mixed question of law and fact may be erroneous. Well, very straight away, the Jamia Masjid 3-bench judgment of the Honorable Supreme Court, headed by our Honorable Chief Justice, I'll just point out one relevant paragraph where this plea was taken that res judicata necessarily is a mixed question of law and fact. My lord, that is an incorrect, it's a very thin line there. Yeah. For the court. Yes. My lord, there's a list of citations which was produced on 18th October 22, 3 citations, 18, 10, 22. Given to the court. Oh, we'll furnish it straight away. Perfect. Give it.
Take that. Yes.
Yes.
Which is a relevant para in.
Yes, conclusion first, and then I'll take your honor to the relevant paragraph. Kindly come to the conclusion at page, manuscript page number 20. My lord's conclusion.
Yes. Para
In-
62.
62, my lord, has? Yes. In
Yes.
view of the discussion above, we summarize our findings below. Issues that arise in a subsequent suit may either be questions of fact or of law, or mixed questions of law and fact. An alteration in the circumstances after the decision in the first suit will require a trial for the determination of the plea of res judicata if there arises a new fact which has to be proved. However, the plea of res judicata may, in an appropriate case, be determined as a preliminary issue when neither a question of fact nor a mixed question of law or fact has to be adjudicated for resolving it.
Yes.
So therefore, my lord,
Then what is the next judgment?
no, this is the judgment which was relied upon by the other side in the impugned order, where it pertained to a case of rejection of plaint, where the court could not have, proceeded beyond the four corners of the plaint, and therefore I could not have, in a order 7 rule 11 proceeding, produced even the pleadings there. My lord, my respectful submission is, when I agitate this issue, if my lord permits, the only call which the trial court will have to take is on the basis of what I show the court, whether anything further, if an issue of fact is pointed out by my friend, which requires trial, that's a different matter. As I see it, my lord, with due respect, my lord, what I see is the court has blindly treated the res judicata in all cases as then, my lord, section 11.
You will be relying only on that.
Absolutely,
On
absolutely.
the judgment. which
Yes,
is already
absolutely. And my
decided
lord,
by the
bar
court.
at law, section 11 is a bar. No suit shall be proceeded with it. My lord, section 11 starts off.
Yes, yes, yes. Now, what about the next matter?
My lord, similar, identical.
No, where you
Absolutely,
every
absolutely.
consideration-
I'll submit.
My lord, if your lordship permits me to intervene, my lord, in the other writ petition, I am not a party in the original suit. He says that I am claiming under the said party. The law is well settled. If I am claiming a right under the party on a day subsequent to the date of suit, then I am covered under section 11. My claim is about 20 years earlier to the date of suit. Hence, to say that they are same is absolutely incorrect. I am not a party at all in the earlier suit.
Yes.
My lord, I'll just complete and my learned friend can.
Yes.
My lord, my request to the court is to look at this case as an independent matter so that we don't confuse issues, my lord. Which is the suit?
And what is the suit filed? for? Same
Again,
partition.
same thing, the release deed subject matter.
Hmm.
I'll take you, first of all, I'll point out the paragraphs of the plaint. My lord, at page 22 is the plaint. My lord, see SNS Plaza.
Declare that the plaintiff is absolute owner of the property.
Yes.
And for consequential order of injunction.
Yeah.
Encumbering so and so.
And here, very
What is
quick,
the source of, according to him, how he is the owner of the property?
he challenges the release deed. Kindly come to paragraph 25 of the plaint at ink page 29.
Yes,
My lord has para 25.
yes,
The contentions there, all A, B, C, D, and E, were the subject matter of the suit in which it was decided against them.
yes. Yes,
And my lord, SNS Plaza entered into a contract with those plaintiffs to acquire that property. And therefore, they sail in the same boat. The contentions taken by them in 1566 by their transferors is the same contention taken by them in this suit. And my lord, for the record, The counsel who appears for SNS Plaza, my learned friend who appears on video conferencing, was the counsel who appeared for the transferors in the suit in which it was decided against them. Now you claim under A, and let me also read section 11, explanation Roman 6, which it very clearly says. Now, if you're sailing as a common interest, you sit on the fence, you acquire rights from your transferor. The transferor is agitating an issue which affects your property. You sit on the fence and watch for the result and the outcome. You claim under them, and then it goes against you. And you want to have a second run because I'm not a party there, though you claim under them. I mean, that is a very superficial argument because the law is very clear, my lord. Anybody or any party claiming under them, let me read the provisions of section 11. Otherwise, my lord, you can have multiple suits, even though you're claiming under a party who has suffered a decree. Therefore, my lord, that's a very superficial argument on, first blush that I'm not a party there. But the fact of the matter is, my lord will have to look, the court will have to look as to whether you're claiming any independent right, like in an obstructionist proceedings, where you say I'm not bound by the decree in execution proceedings. But if you claim under the judgment data, then it's bound. Though you're not a party to that proceeding, you're bound by it. Section 11 applies on same footing. And here, you were aware of it. Your counsel who's appearing for you has appeared and argued at length and contested the matter. Issues were framed and decided against your vendors. And now for you to say, I'm not a party there, would be a very superficial submission, my lord.
Yes.
And that is all there is. And I'll take my lord to the impute. And my lord has seen the contentions again squarely on the release deed. Everything hinges on the release deed. If the release is upheld and B and C has been upheld to be in my property marginal land, and that has attained finality, there is no scope at all, my lord, for these suits to survive. Is my lord will not take a call. Possibly, my lord will direct the learned court below to consider this preliminary. I'm sure my friend will have an opportunity to say that there is an issue of fact to be decided and therefore it should not be decided. I'm not calling upon due respect, my lord, this court to decide the matter here as a court of first instance. My lord will, I would only request the court to remand it back for the court to reconsider it whether a preliminary issue lies or not on the basis of the only pleadings which I have submitted before this court. My lord will see the impugned judgment.
It's on the similar lines.
No?
It's on the similar lines.
On similar lines.
My lord,
Yes.
my lord, may I submit, my lord? My lord,
Yes.
let us say A sells the property today to X. Tomorrow, without making X a party, a suit is filed, then we are bound. Supposing A has sold a property 2 years back, a decree suffered by A as on today will not be. A person is said to claim under a party if the rights are claimed on a day subsequent to the date of suit. My lord, my learned friend Rajaditya is there who argued for the other one. He is having some judgments. May your lordship may kindly.
Now, what is the case of the plaintiff?
Case of the plaintiff is that they are the absolute owners of the property. That is with respect to what was given by way of a release deed. What he says is correct. But I am claiming a right on a day much earlier than the day.
You are also part of the family.
No, I am not a member of the family. I am a purchaser or I am a person. Page number. Page 25. My lord, your lordship may kindly come to page number 22 of the book, my lord. Page number 22, where the plaint is there.
Yes.
My lord, plaintiff is SNS Plaza, my lord.
Yes.
Your lordship may kindly come to page number 25.
Yes.
The plaintiff submits that a partnership, as originally the partnership form was constituted and a deed of partnership dated 1/10/1985. A copy of the partnership deed is produced. The partners, among others, included Shamla, Venkatadri, SS Pandit, who were the owners of the property, and bearing number such and such, etc. They invested portion of said property which is owned by, etc., etc. So, my lord, I am claiming right under a document of 1/10/1985. I am not claiming a right subsequent to the date of that suit. May I request your lordship to kindly come to the decisions that I have given, my lord? The first decision is 78 Allahabad. Your lordship may kindly come to ink page number 5. From the bottom, about 5 lines earlier, it will be seen that the earlier suit was instituted on 6/12/1969. The lessee rights in favor of the plaintiff respondent in this appeal had been created with effect from 1/2/1969. In other words, those rights were created before the filing of the said suit 6/12/1969. Then your lordship may kindly come to para 9, next page. Para 9. Your lordship would get it, my lord? May I read?
Yes.
A large number of cases have been referred, etc., etc. Therefore, applying the said principle of law to the facts of the instant case, as the transfer of lessee rights by the Nagarpalika, etc., in favor of the plaintiff respondent was prior to the institution of the earlier suit, the decree passed in the said suit cannot be res judicata against the plaintiff respondent in the instant suit. In this view of the matter, it is not necessary to discuss the other aspects of the matter because due to the aforesaid position of law, it has to be held that the courts below were right in not treating the decree of the res judicata. Then your lordship may kindly come to the next decision of our own High Court. That is 85 Karnataka 123. May I request your lordship to come to ink page number 12, para 7 of the judgment, my lord.
Yes. Yes.
Para 7, 4th line, my lord.
Yes.
A person is said to claim under another when he derives his title through the other by assignment or otherwise. The right claimed by him must be attributable to the party in the former suit, and further the right must have been acquired subsequent to the commencement of the said suit.
Yes.
The last 3 lines in the para. Section 11 does not contemplate a case of a person who is a predecessor in interest of a party to the former suit. The expression under whom is inconsistent with any such theory. If she set up any claim of this case, it is in her own right and not at any rate under section defendant number 5 who was a party to the former suit. The next decision your lordship would kindly see is at page number.
Yes.
Come along. 15, your lordship may kindly come to page number 19.
Yes.
Para 7 of the judgment.
Yes.
About 4th line. A person is said to claim under another when he derives the title through the other by assignment or otherwise. The right claimed by him must be attributable to the party in the former suit, and further this suit must have been acquired subsequent to the commencement of the said suit. Last 3 lines. Section 11 does not contemplate a case of person who is a predecessor in interest of a party to a former suit. The expression under whom, same words that was used in the other judgment is used here, my lord. Then, your lordship may kindly come to page number 23. Actual page number would be page number 27.
I've seen that judgment also. Just now I've read, yes.
Yes, ma'am. So I am claiming, the plaintiff says I am claiming in 1985. They are telling the suit of 2007 is binding on me. How can any court say that I am claiming under them?
2007.
Yes, suit of 2000. My rights I am claiming under 1985. So how can res judicata apply? And one question your lordship would kindly see, one of the questions that has to be decided, one fact which has to be decided is whether I am claiming it earlier or later is a question of fact which is to be decided. Yeah, once there is a question of fact to be decided, the court can never treat it as preliminary issue.
Heard, reserved.
I have one submission.
Yes.
Since my learned friend took this court through various facts, the petitioner advocate, I'd like to point out that in the earlier judgment, which he says that I have suffered, I have not suffered it. The release deed was not at all executed by me. That has not at all been brought forward by the petitioner advocate. It is only my brother who executed the release deed. In the operative portion of the judgment, the Honorable Court has held that Shamala Venkat, the second plaintiff, had absolutely no cause of action to file the suit because she is not at all a party to the release date, and it does not affect her rights in any manner.
Yes.
Now, my rights have been safeguarded in the earlier suit. Subsequently, they have interfered with my rights by executing a sale agreement, ignoring my right. That gives me a fresh cause of action. Now, an opportunity for me to prove a fresh cause of action should be given to me. I should not be shut out by a preliminary issue.
All we are
I'm
seeking-
already 80 years old.
No,
I
all we
cannot
are
be
seeking
vexed.
is for the court to take a call, and my friend's submission and my learned friend's submission will be considered by the court. And then,
So-
my lord sees the point there. Yes. I'm very grateful.
Next.
For the petitioner in this matter.
Respondent in this case, my lord.
Connected matter, I am for the respondent.
I'm for petition, my lord.
What is this petition?
Challenging the maintenance of
Appeal
audit.
for the wife or husband?
He's for husband, my lord.
I am
I'm
for the
wife, my lord.
First petition is by the husband.
Yes, my lord.
How much is the maintenance? value?
25,000, my lord. 25,000 maintenance.
They are seeking
10,000.
enhancement.
I am seeking enhancement, my lord.
Hmm. What is the salary of the husband?
Doctor,
Salary, doctor, my lord,
Stal
he's a profession.
is practicing as a physician, self-employed.
Income is?
He has declared
50,000.
50,000, my lord.
They
Income
themselves,
is, according to it, is 50,000.
Yes, my lord.
What is the wife doing?
He's not working, my lord.
he is,
She's a graduate, my lord. She's an LLB graduate. She's not working.
Any children?
My lord, one child, major child, my lord. She's pursuing her LLB, girl child, my lord.
And she's not working.
She's not working.
Why?
My lord, she, due to medical reasons, she can't work, my lord.
What are the medical reasons?
Stroke, she has, due to the harassment, my lord, once a stroke has been happened, my lord, due to which her blood pressure varies, my lord. Someone should be there to look after her, my lord.
Please come to the order.
In first petition, my lord, page number 13, order starts, my lord.
Yes.
Page number 24 is the asset and liability consideration, my lord, reasons from the order. Page number 23 will be, ink page number would be relevant portion. my lord.
MC is not decided so far.
Not at.
It's MBBS doctor.
Yes, my lord. He has his own clinic, my lord.
No, any specialization, that's what I'm
No,
trying.
no, my lord.
MBBS.
Physiatrician. Physician.
The amount is 18 lakhs is already paid.
Yes, to the daughter, my lord.
No, it says a permanent alimony.
No, my lord. That has been observed, my lord, in page number 26, para 20, my lord, of the impugned order. It has specifically addressed, my lord. It has not paid by him also, my lord. His siblings have paid. His siblings have paid, not by the husband. Because husband neglected the wife. She sought for other remedies, my lord, where his siblings have paid the money, my lord, not by him. He has not even produced single document to that extent.
He even have a agricultural income, my lord, which he didn't disclose in asset and liability. Where
How
this,
did you disclose it? How did you?
my lord,
show-
I have produced the documents, RTCs, my lord, at page number 25, in page number 25, para 19. my lord.
What are the,
Agriculture lands which generate commercial
how much,
crops, my lord.
what is the extent of the land?
My lord, around 8 acres, my lord. There are 3 survey numbers, my lord, which is jointly owned by each son, his father name, my lord. He doesn't have anybody to look after, my lord. There are no dependents on him, my lord. All are well settled, my lord. Even that has been observed in the interim order at page para 23, my lord.
Yes,
Lordship, take your lordship to page number 29.
I've seen the order, yes.
Now, my lordship, it's the maintenance has been ordered with respect to 25,000 rupees per month and 10 rupees, 10,000 to the petitioner during the for the legal litigation expenses. Lordship, I'll take your lordship to page number 24.
Yes,
I'm sorry, my lord, page number 38. Paragraph 14. Now page 36, my lord. The paragraph 10, the petitioner submits that since expenses of the family raised after the birth of the daughter, petitioner joined as a teacher in Marti Vidya Kendra for a meager salary so that she can take care of the child needs. The respondent after the birth of the child became alcoholic and began so on so. The reason why I've read this paragraph is to make clear that she was working as a teacher in a school. She is an employee. She is capable of earning for herself. And the next paragraph is that I'll be relying upon some of the judgments where if any of the spouse is capable of earning and is qualified, where the maintenance need not be paid. Now,
where do you pay, no. Living with the parents at doing odd jobs.
so this is to establish that she was working earlier. Now at page 38, my lord, the petitioner submits after 2013, petitioner ever went to the matrimonial house and is presently living with her parents at Tumkur doing odd jobs. The respondent has abandoned the petitioner and their daughter has not paid any money for their maintenance and education expenses, seeing the plight of the Kumaris also. For education, siblings of the respondent on their advice, respondent collectively has paid. Respondent has collected, whether I pay or my siblings pay, it doesn't matter. It accounts that as if myself has paid an amount. It is 18 lakhs we have paid towards the pyramid. It's not only for the daughter. It is for the expenses of they are sought for the educational purpose and for the maintenance of the petitioner. This is what the amount we have paid. It is my learned friend says that it has been paid for the educational purpose. It has to be matter of the fact has to be decided at the time of trial. Now, they say true that even they admit that I have paid 18 lakhs to them. Now, I'll take your lordship that where she has admitted still today, she works. At page 53, my lord, our assets and liabilities. 41, my lord. 41. Page 53. Lordship, page 53. Column 41, my lord.
Yes.
In case of self-employed person, she has mentioned working as a designer in her father's garment, earning rupees 10,000 per month. I have clearly stated in my objection that what is the boutique she is running. She is the one who is running the boutique. But
Has she filed her bank statement?
she has not filed her bank statement. In
Even
fact,
they have
we
not
are
filed the bank statement, my lord. Even they have not done it. My lord,
now
we have
I'll-
produced the statement before the trial court, my lord, not before my lord.
Yes. I'm asking about before the trial court, not before this court.
The trial court has been done, my lord. We
It's
had filed
filed.
3 years back.
What is her bank balance?
Right now, she is, 10,000 is what it has been shown, my lord, per month, nothing more.
No, having taken 18 lakhs as permanent alimony,
When,
where is the question of,
my lord, 18 lakhs is not permanent alimony to me. That is what I'm trying to establish. It is not paid by him also, my lord. Siblings have.
so why
supported
would
me.
siblings pay to you?
It's to the
They would
daughter
pay, they would
education,
pay
my lord.
for the sake of brother. They don't have any relation with you.
No, my lord. Yes, they don't have any relationship with
Yes.
that has been paid to the daughter, my lord, not to me. He himself have declared the same thing. It has, hence, I am claiming my maintenance, that's it, my lord, not the daughter maintenance.
No, no, when was this IA filed? Criminal miscellaneous, when was this IA filed?
Well, I filed along with the petition, my lord. Petition was filed on 3/8/2022.
No, right from 2023, what is happening from 2013? You left the house in 2013.
Yes, my lord.
What is happening from 2013 to 2020?
I was in my parents' house, my lord.
Hmm.
I approached all the relatives along with the siblings. At the time they paid, on that basis, I sustained my whole thing, my lord. No, he read only the para at page number 38, my lord. He read only the para where he said I was doing odd jobs. Subsequent to that, I was met with an stroke, my lord, where I undergone the medical treatment. He didn't read that para. Next para to that,
Now,
where which all the treatments that has been done is on the basis of the payment that has been received, my lord.
page 53 clearly speaks about the present job. That's what I read. in
10,000, my
column.
lord.
No,
10,000
10,000
is
is.
what it is.
And moreover, I have made a clear statement in my objections, my lord. In fact, she is the one of the law officer in the Star Health Insurance.
That has
Where
been-
I am supposed to secure those documents, I should summon from the court
My lord,
to
that has been-
establish that whether
that
she
has
is
been-
earning. I do
that
have the visiting card, but visiting card does not mean that that doesn't mean that it's a
It's
prima
come-
facie evidence.
My lord, that has
And
been
now
considered
your
in the
lordship may-
trial court order, my lord.
May make one submission, my lord.
Lord,
In their
please,
petition,
Please see para 17 of the trial impugned order, my lord.
I have read the order.
Their claim has been considered,
Yes,
that they have not produced anything, my lord.
yes,
I'm not working also, my lord.
yes.
one submission, my lord. In fact, they themselves has furnished a photograph before this honorable court in their petition.
Yes, my lord.
The physician, this clinic has been shown. Now,
His name is shown, my lord. It is written in
not
Kannada.
denying it. That the photographs clearly speaks about the where, what is the clinic, how he holds the clinic. my lord. He's a doctor.
You
where it's-
admitted that it is 50,000 is
Yes,
your
my lord.
income.
Yes, now the question is, my lord, he is the doctor where he is rendering his service in a Obli headquarter, not in Taluk headquarter, not in a district headquarter.
No, no,
It's a-
we'll take it as 50,000 as you said.
Yes, my lord.
Income as
There-
50,000.
But agriculture income was not shown in the certain.
Allah, may I put it across?
That is,
Agriculture income, my lord. Let
That's a
this no
commercial
court does
property.
not take care. Other way around, my lord. Even I am an agriculturist. I also own a coconut plantation, coconut plantation. Even we own 100 acres of plantation also. We know how difficult for an agric farmer to grow. But they say that, let me complete.
Yes.
See, there's an coconut plantation as well as coconut plantation. It is not that 8 acres of land. That doesn't mean that the entire 8 acre land is been coconut or coconut plantation. In fact, how many coconut plantations are yielding? What is the price on this day? Today's price, what the coconut is.
No, no, all those things will not go. Yes,
But
that is what.
my-
so you
Now,
submit-
submission
the
is-
50,000.
no, my lord. My sub-
Simultaneously, both of you can't argue. Let him argue, I'll
Yes.
hear you.
Please, my lord.
Yes,
Now, the question is, my lord, in fact, I'm furnishing some of the judgments, my lord, even today, if they are ready to come with me, I'm ready to take her to my residence.
Not, I am ready
Ready to
to,
go, I'm ready to take her.
my lord. I'm ready
Even
to
in the
go.
mediation, I have made a submission that
Not
he
letting
wants
you
to take you back. You want to go.
yes, from.
May I?
What is stopping you?
No, my lord, may I?
Uh.
He is showing before the court that he wants to
No,
take me
no,
back.
no.
He is not, my lord, I am ready to go 2 times in a mediation center. He didn't appear. He said once he said he is going to come. Subsequently, he didn't.
See, if yes,
Even, my lord,
No, no.
till today, my lord, he took 9 months time to sort all those things, my lord. Even till today, he is not, my lord.
File an affidavit before the court that you.
I'll do that, my lord.
Do
I'll
it.
do it. If they're.
Close this matter on
Sir.
16th. It is submitted by the learned
Parties
counsel
will-
for the petitioner that he is ready to take back the wife. Learned counsel for the respondent submits that. The respondent wife submits that she is also ready to join, but on several occasions, he has failed to take her back.
No, it's not failed to take her, but he says that I have not appeared before the mediation.
He has not, though she was ready,
Was-
he has not appeared before the mediation center. In this regard, the learned counsel for the petitioner, husband shall file an affidavit before this court.
Please, my lord. A date may be. given.
Pose this matter on 16.
Obliged.
Yes. Yes.
No, then for the petitioner wife in the main matter, madam, I am seeking enhancement of interim maintenance, madam. 15,000 is what is granted, madam. In my application, I had sought 30,000 as interim maintenance, madam. 30,000 as interim maintenance is what I sought under IA number 2. What is being granted is 15,000, madam. I have filed this writ petition seeking enhancement of the interim maintenance, madam. My ground is that,
Questioning the maintenance.
yes, madam.
Now what is the income of the husband?
He has not filed as assets and liabilities in the trial court, my lords. I am told that it is over 1.5 lakh per month.
But basing on what the court had granted?
My lords, I'll come to that. I had filed my statement of assets and liabilities.
What is your
As on the-
qualification?
BSc, my lords. As on the date of
How long you were together? When was the marriage?
2013, my lords,
2000?
13, 2013.
Separated when?
Separated, there's a dispute regarding when they got
For your
separated.
case.
15, my lords.
MC is filed when?
My lords, this is interim maintenance, my lords. That is what,
That is under 125.
125, my lords.
Which year?
2022, my lords.
You also not filed your statement of assets and liabilities?
I have filed, my lords. The trial court proceeds on that basis, my lords.
Why you
as
have
a-
not filed?
Lord, the matter was referred for mediation. Meantime, the case posted for hearing on IA, my lord. Meantime, the order was passed, my lord.
No, we'll set aside this order and remand the matter to the court below for fresh
Obliged.
consideration. And you will continue to pay this 15,000
My lord,
till the application
My
is
lord,
decided.
Before, my lord, I'm previously also I'm paying 10,000 for the maintenance to the
Is
respondent.
it correct?
Towards,
Petition itself, they are
towards
updated,
the
my lord.
child's fee, claiming to be the school's
Not
fee,
only
that is
my
what
lord,
is being
I'm
paid.
also paying the child fee also till 2020.
My lords,
I'm paying
let
the
me
school
complete.
fee.
2022. What has happened after that?
After that, she filed maintenance case before the family court.
That's why you stopped paying.
And not like that, she's also earning, my lord. She's also getting more than 35,000
Now,
salary.
because the only why the matter has to be remanded now is because of the lapses on your part in not filing the statement of assets and liabilities.
Obliged.
For that, the order has to continue. Let the court decide basing on your statement. Till such time this order, the payment of 15,000 will be operative. Please
Obliged.
come.
My lords, I have one more submission. As on this date, I am unemployed. I was forced to resign from my work because I was working from home.
That aspect we are not going into now.
Very well, my lords. In
The-
that case, my lords, I have another submission to make. I have filed a petition under 125(3) for execution of this interim order. He has not paid any maintenance as of now, even after the order.
They're all independent.
Very well.
That is for him. Now, as long as this 15,000 order will be in force,
Very well.
as any order is passed. So
Very-
he has to rush before the court for filing all relevant documents.
Very well.
And the execution, everything is open to you.
Very well. Much obliged.
The agreed with the order passed in. Where is the order?
Annexure A, my lords, page 21 onwards.
Agreed with the order passed in criminal.
Miscellaneous 562 of 2022, my lords. Relevant page is page 23.
Agreed with the orders passed in C miscellaneous 560 in IA number 2 and C miscellaneous 562 of 2022 dated 22 to 2000.
24, my lords.
24.
22 to 2024, both the husband and wife are before this court. Husband, your first is yours.
Yes, ma'am.
Wife had filed WP 13794 of 2024 seeking enhancement of maintenance, and the husband had filed WP 12772 of 2024 seeking questioning the maintenance granted. In WP 12772 of 2024, Mr. Vinayak S. Pandit takes notice, is directed to take notice on behalf of respondent. The wife had filed IA number 2 in C miscellaneous 562 of 2022 seeking interim maintenance of an amount of rupees 30,000 per month. It is her case that she is a BSc graduate and she's after she was after she left the petitioner, left the husband in view of the different disputes. She's staying with her younger sister in the rented house. And out of the wedlock, they're blessed with a boy and who are blessed with a girl who is aged about 10 years.
11 years.
I'm looking from the order, 10 years. And she's suffering from speech-related problem and taking treatment for the said issue. It is a case that petitioner's monthly income is 16,000. What is petitioner's monthly income is 16,500.
As on the date, I was working. My assets and liabilities disclosed that I was working. Subsequently,
Working and her income is 16,500.
as on the date of filing of application.
Submission.
Yes.
In our entire petition, she is not disclosed her job status. After filing our objection, we make submission. As after that only she admitted her.
According to her, she paid an amount of rupees 8,60,000 to purchase the flat. And it is a joint ownership. And according to her, the salary of the husband is 1,50,000 per month. And he is having other mobile and immobile assets. And a fixed deposit of rupees 10 lakh. And she has placed before the court a place which discloses her salary was rupees 35,869. What is this?
It was told basic pay and the other incentives and all.
Her
of-
salary,
Yes, my lords. That as on that date, my lords. Now she is unemployed.
36,000. Why these kind of petitioners' income is 16,500? You should say, what is your salary?
Kindly peruse her petition, my lord. Page number
The
33.
more than 35,000 per month. She also produced the bank statements and other documents. The court observed that the husband had not filed his objections or complied the order of filing of assets and liabilities. Wife had filed a statement of assets and liabilities. Court considered the income as rupees 16,500 and the fact that she has to take care of herself and her daughter. The court granted an amount of rupees 15,000 per month as maintenance. Next, land counsel appearing for the petitioner wife submits that when the salary of the husband is almost more than 1.5 lakh, the court had granted only an amount of rupees 15,000 as maintenance, which is not sufficient to maintain herself and the daughter. It is submitted that though she was working as on the day, now she is unemployed.
As on the date of filing of the
As
application.
on the date of filing of the application, but later she lost her job and she was not working.
My lords, I have produced the resignation letter also, my lords.
Why
Next to the end.
resign?
She can work, my lord.
Work from
Still
home.
she can
That
work,
would-
my lord.
I was working from home. After the COVID-induced lockdown was eased, I was asked to come back to the office. And I could not do that because I had to take care of the speech impaired child. So she
And I
needs
should take care
attention.
of the child. And no permission was granted to work from home. She had resigned the job. According to the land counsel, the petitioner, she is not working. And the court below ought not to have granted the amount of the 30,000 as maintenance. Next para, land counsel appearing for the husband submits that the court that as the matter was referred to mediation, he could not file his statement of assets and liabilities. It is submitted that initially the wife had not disclosed about her
Employment.
job and income, and later the same was disclosed. It is submitted that the true facts are not placed before the court. It is submitted that he is paying 10,000 till the petition is filed for the child. It is submitted that if an opportunity is given to the petitioner to file a statement of assets and liabilities, he would be able to, the two facts will come to light, and it would help the petitioner, as well the husband, it is also it is also in the interest of the wife that once the statement of assessment liabilities are passed, she can also she can file her file her objection, and also she can present her case. This court, having got the counsels on either side, peruse the material on the court. The dispute, the court had granted, the wife had sought for 30,000, court had granted 15,000. It is a case of the wife that she's working, and later she decided as she had to take care of the daughter. The husband has not filed the statement of assets and liabilities. So liabilities, unless the statement of assets and liabilities is filed, it cannot be decided. The court cannot come to a just conclusion. What is the income of the husband and how much maintenance the wife is entitled? The husband ought to have filed the statement of assets and liabilities when an opportunity is given to him. Considering all these aspects, the order impugned before this court is set aside. However, till the application for the interim maintenance is decided, the husband shall continue to pay 15,000 per month. The next point, 15,000 per month, and the arrears of maintenance, if any, till the order is passed by the court below, shall be treated as 15,000. Accordingly disposed of.
My
And the
execution
court will-
petition.
Shall decide the application within 2 months from the date of receipt of the copy of the order.
My lords, and my petition for execution of arrears, that it may not
That
come
is
in the way.
secured. I have not stopped anything.
Very good.
If there are any arrears, the wife is at liberty to recover the same.
Much obliged.
Yes. Huh? Both are, the order is set aside and the matter is remanded to the court below. Yes. Who appears for the respondents?
Mr. Annaya.
R1 to R3. What is this petition?
Actually, the petitioner and the third respondent are the grandfather is the owner of the suit scheduled property.
What is the suit for?
Suit for declaration. Even though he is the absolute owner, he filed for declaration. The suit came to be dismissed. For that, he has filed an appeal before the appellate court, RA. That was abated. Subsequently, he has died. It was became abated. He filed an application. Petition and third respondent filed an application before the appellate court to set aside the abatement. The abatement application was allowed, but legal representative application was dismissed, stating that gift deed has not been produced. In fact, gift deed has been produced before the court. It's not at all posted for evidence before the tribunal after the matter was remanded by this.
See the order. Let's see the order. Page number.
Page number, my lord. Twenty onwards.
20 onwards, yes. Venugopal. No. Suit is of the year 2010. RA is filed, no, suit is, suit is of which year?
Suit
Is
act-
1999.
Yes, my lord.
OS 1999.
Fif-
And,
First- 50, first it
and
was,
then RA was of 96 of 2009.
yes, my lord, after disposal.
Then when you filed this IA,
Immediately after that, application was also.
where is the affidavit?
Application.
Application.
Immediately after that, we have filed.
No, what is immediately after that? The court has to know.
This is page number 11, my lord. Application.
No date on the
I'll
application.
tell you, my lord, date we have mentioned. The order.
No, at
said
least
date.
looking at the objections filed by them, it contains the date.
Yes.
In the year 2011.
Yes, ma'am.
An order is passed when, what is the date of the impugned order?
19th March 2016, my lord. First, what happened, my lord, in this,
19th March 2016.
yes, ma'am.
What is the order, what is the order passed by this court?
In this challenging 5622, it was
Give that-
remanded back.
Give the order sheet.
Or 5620. Edit order like.
No, this order sheet itself is a big, like a judgment of the regular appeal. You have not taken any steps till 15/4/2024 to get this matter listed, to serve the notices.
Taken, my lord, taken.
Only one memo is there in the court.
Process has been issued subsequently, application also allowed, my lord. My,
No,
that's
what are the efforts from your side? A suit of 29, 2009
2001.
and is pending till 2024. And just on the gun, first of all, when the plaintiff dies, you file an application after some time with the delay, and no writ petition of 2016 is not pursued. No, the matter has to be posted for dismissal.
No, actually, I think last month it was posted that application, we are argued on that application, it was allowed, my last month.
No, where is the gift deed? Gift deed.
Gift deed, it's here, I produced along with this petition.
For such a simple matter,
Yes, my lord.
it's not right on the part of the party to keep these matters pending like that and
29, page number 29, my lord. It's.
20?
29 onwards, two gift dates are there, 29 and 36.
When was it registered?
Registered in the year 29/4/2008, my lord,
29/4?
2008. He was the absolute owner, he has executed the gift deed in favor of his grandsons, my lord. First respondent is not.
You know the counsel for the respondent?
One Mr. Anaya. Is to appear.
We will, please inform him, pass over, we'll pass orders in the afternoon. Pass over.
Yes, Commissioner,
Yes.
I have filed application for recalling order dated 9/2/24.
9/2/24.
24.
Where is the order?
No, my lord. Before this order sheet. Because I have not taken steps to
Then what is to be done? Why should it be recalled?
Subsequently, I have filed the NOC wakalat. That's it.
No, because you filed one NOC wakalat, the facts would not change.
Please.
When was it dismissed?
9/2/24.
Why should it be restored is the question.
Who are,
It's a writ petition of
who are handling,
2017.
please, who are handling this matter, she left office. She left the office meeting.
Oh, that is not the issue.
Please.
Whether she left, she's there.
Please.
Why should now? In a
Subsequently,
2017 appeal, writ petition, if you're not taken the process,
please,
court was perfectly right in dismissing it.
please,
And this court sees no reason to restore it.
request.
Huh?
Request.
No request can be considered.
Because
No request can be considered.
227, this suit.
Learned counsel for the petition is neither present physically nor through video conference. No reasons are forthcoming for the non-appearance of the
Please,
counsel. According to the registry, with respect to the issuance of notice to respondent number 2 to 7, till date, the petitioner has not taken steps even for the first time. A perusal of the order sheet would go to show that initially on the date of 12/6/2017, no notice was issued to the other respondent except ordering emergent notice to respondent number 1. However, subsequently on the date, notice was ordered to all the respondents. Thereafter, the matter came up before the court on several dates of hearing. In spite of the time till has not taken steps to ensure the service of notice upon respondents 2 to 7. Under the above circumstances, and the petitioner himself is not evincing any interest for ensuring service of notice upon so and so. In this petition, so there is no point. Where is your affidavit? Let us see.
Please. 18/6/2020.
Yes.
Myself update only.
The colleague of the council,
Please.
and I know the facts.
Para.
This can't be a ground, Mr. Council. Please
Request my
come.
lord.
The present
Request my
application
lord.
is filed on 18/6/2024 to set aside an order passed by this court on
9/2/2024.
9/2/2024.
Today itself I will take my lord.
9/2/2024.
Because the suit is for,
Court on 9/2/2024
suit is for partition.
has observed, still we can't help it. 9/2/2024, this court has observed that in a writ petition of 2017, till now, no steps are taken to serve notice on the respondent, even for on the first occasion. The court observed that on several occasions, there was no representation on behalf of the petitioner, which shows that the petitioner is not evincing any interest for ensuring service of notice upon the respondent number 2 to 7. And passed an order that the petition against respondent number 2 to 7 stands dismissed for not taking steps. Now the present IA is filed seeking restoration of seeking to recall the said order by a petition dated 18/6/2024. Unfortunately, even for this also, when an order is passed on 9/2/2024, conveniently after 4 months, the present application is filed. And the application do not contain not even one single reason.
Para number 5, my lord.
It is stated that by oversight, no steps are taken.
Please.
Service of notice to respondents. On 9/2/2024, the colleague of counsel for the petitioner was supposed to attend the court, did not attend the court, and there was no representation, hence it is dismissed. Why the process is not paid from 2017? Absolutely no whisper, except saying that the colleague has not attended. These kind of petitions cannot be entertained by this court and entertained by this court, and this court finds no reasons to recall the order dated so and so, accordingly dismissed. There is a list. Yes. Next matter. And even now the matter is coming up before this court for dismissal, as there was no representation
Respondent.
on 26/2024. The matter was directed to be listed for dismissal.
No, I am ready to argue, my lord.
Not argue. Why? The court has to hear you. Now for you should unless and until that notice is reserved to respondent, where is the question of hearing?
Respondent
it on-
number 1 is appearing. One.
Yes, then what will remain in the suits for party, now whatever the order that is passed.
Reason.
And now if they are not there on, it virtually amounts to,
Respondent number
the
1 is
petition has
served.
to be dismissed.
Respondent number 1 is served.
Give that.
I'm for the respondent. you asked.
What is IA?
IA for at 9 rule 13.
Where is it? Oh, there also same problem. Where is page number?
No, my lord. He is not responding.
Huh? Yes, anyhow, notice is served on the first respondent.
Please, ma'am.
Where is the order? Page number?
No, in the, this one.
Huh?
In the list also, cause list also shows served.
No, no. I'm saying where is the impugned order? Which
Impugned
page
order is-
number?
Impugned order at page number 52, annexure G. Annexure G. In fact, here, respond number 1 to 4, they have said no objection to allow the application also.
1/7/2014.
Here, annexure E is a Kannada version. Annexure E. Because not given opportunity to cross-examination the witness.
Now, where are your objections? Not objection, your IA, your affidavit, where is it?
Application is at
Page number
page number 41, annexure D, my lord.
41.
Please. Due to ill health, unable to
When was it filed?
filed on
2/9/2015.
Please.
That is after 1 year, 2 months. So where did you say about the knowledge? How you came to know? What was your case?
Here, para number 4 of the petition, the petitioner recently came to know knowledge of the ex parte judgment and decree against petitioner, and they have.
You don't have to tell the date. When is that recent?
They didn't mention recently.
Please come. The present revision is filed. Agreed with the order passed in miscellaneous number 19 of 2014 dated 1st October 2016. The petitioner herein is a defendant in the suit. The respondent herein filed a suit for partition. The suit came to be decreed on 1/7/2015. It is a case of the petition herein that the plaintiff colluding with the other defendants created some documents and filed the suit. He gave wakalat to some other advocate by mistake. He failed to file the written statement. Later, he filed it through another advocate. The respondent one filed affidavit in lieu of examination in chief and God marked some documents. He was not cross-examined by the plaintiff. Because he was suffering from asthma, he had been to NR-Pura for treatment. Necessary application filed seeking permission to cross-examine PW1 was not allowed. Meantime, he was trying to settle the matter amicably and finally the court has delivered the judgment. Petitioner is innocent and hence prayed to allow the petition. Petition filed under Order 9/13 to set aside the ex parte order, ex parte judgment and decree. The same was opposed by the plaintiff. The court had dismissed the same by order dated 1st October 2016, wherein court has observed that the petitioner has appeared before the court and the court has recorded that the defendant evidence is nil. Thereafter, pronounced the judgment. The court observes that the sufficient opportunity is given to the defendants to leave the evidence. Whether with regard to the medical condition or that,
Plaintiff itself filed a 9/13 application, not defending.
you are the plaintiff in the suit.
Please.
The petitioner is a plaintiff in the suit and he has filed a suit for partition. It came to be decreed.
No.
The plaintiff is
Agreed,
the
agreed.
petition is a plaintiff in the suit. It is his case that he has filed a suit for partition and the same was on by order dated
1/7.
1/7/2014, an ex parte judgment and decree was passed. He filed this application to set aside the ex parte judgment and decree, and the other reasons remain to be the same. So it is stated that the court below, without giving an opportunity and without considering the reasons stated, had dismissed the application filed under Order 9/13. This court has perused the order and the court below had observed that no reasons are stated or no documents are marked to show that why the plaintiff was absent. And in spite of giving an opportunity, why he has not read the evidence. When counsel appearing for the petitioner submits that
In fact, respond number 1 to 4, they said no objection to allow the application.
submits that in fact, respondent number 1 to 4 have stated that they have no objection to restore the suit. In spite of that, the court has not considered. The suit, an ex parte judgment and decree was passed on 1/7/2014. Then the present IA came to be filed on 2/9/2015. Even in the IA filed in support of the affidavit filed in support of the IA, nothing has been stated when he has come to know why he has not come before the court except giving vague reasons. And that is dismissed by the court by order dated 1st October 2016. He has approached this court by filing the present writ petition. In the said writ petition, as he has failed to,
Another order also,
and when he has failed to,
MA number 15 of 2016, dated 12th April 2017, Annexure J, my lord.
again is that he has carried the matter in appeal. Where is the page number?
62, my lord.
Carried the matter in appeal. that is MA number
15 of
15 of 2016 dated 12th April 2017. That also came to be dismissed by order dated 12th April 2017, wherein the appellate court has observed that the court below had rightly dismissed the petition filed under order 9/13. And as far as these applications are concerned, appellate court is having limited jurisdiction to form any opinion other than the opinion formed by the trial court concerning the relationship between the parties, non-production of the documents about asthma and his ailment. Court had affirmed the said order passed by the trial court in the miscellaneous number so and so. Now, when the appeal is filed, petition is filed before this court, which is in the year 2017, even for the first time also, no process was, he has not taken steps in respect of respondents
7. 7.
227. And by order dated 9/2/2024, this court has dismissed the appeal as far as writ petition as far as the respondents 227 are concerned. And even before, thereafter, a recall application is filed. As there was no representation before this court has also has posted the matter for dismissal. And now the order, that is the application that is filed to recall the order dated 9/2/2024 is dismissed. And dismissed. Now, as far as this writ petition is concerned, only the first respondent is the one who is served. And that only is now operative against the first respondent. Concerning the whole facts and the manner in which the litigation has been pursued by this plaintiff right from the year 2012. This court finds no bona fides on the part of the plaintiff in pursuing the matter, and no reasons are placed either to set aside the order passed by the court below, and also looking at the conduct of the parties petition plaintiff before this court also. This court finds no reasons to interfere, accordingly dismissed.
For the respondent, Your Honor.
Yes. What is this? With the docket in all these matters, it is required. This court on 13/6/2024 1 minute. This is a writ petition of 2017. An interim order was granted on 24/7/2017. And then on 2011/2019, the same was extended. On 27/1/2023, an order was passed that though respondent number 1 expired, till date, the petitioner has not moved any application to bring the legal representatives on record. Hence, the petition against respondent number 1, an order of abatement was passed. Then on 12/7/2023, as no steps were taken even on that day, court has granted further time to to file an application on cost of rupees 500 payable to the High Court Legal Services Authority. This indulgence is shown as final chance. Then when the matter came up on 5/2/2024, a memo is filed saying that he filed a cost of rupees 500. The matter was directed to be listed after 2 weeks. When this matter came up before this court on 4/6/2024, at the request of the land counsel, the petitioner, the matter was directed to be listed on 13/6/2024. On 13/6/2024, this matter was directed to be listed on 26/2024, and by that time, the council shall file an appropriate application for bringing the LRs on record, or else the writ petition shall stand dismissed. As per the office note, no such it appeared before, though the matter was there in the list on 26/2024, 4/7/2024, 9/7/2024. And the same was not, reached. Now, today when the matter came up, and when the matter is listed under the caption for dismissal, the land counsel for the petitioner is not present. The court had been accommodating the counsel for the petitioner right from the year 2017. And this cannot go on. And writ petition of 2017 can't be kept pending, facilitating the petitioner to take his sweet time. It appears that the petitioner is not vigilant in pursuing the writ petition, and the same is dismissed for non-compliance of the orders dated 36/2024, and also for non-prosecution. Yes. Yes.
Jesus, I have filed application for recalling the order dated 24/9/2001 during.
Office objections raised on IA number 1 of 23
That
for
is,
recalling not complied so far.
that is, my lord,
Who filed the recalling application?
I have filed application. Firstly, the learned senior counsel has, the counsel appearing for R1 has become senior counsel. So thereafter,
Give that.
his junior one, Vinod Reddy has filed a wakalat on behalf of R1. So he's saying that no, I have returned the file to the senior itself. So recently, so he has received and given acknowledgement. I have served the copy to the R1. Regarding R6 is concerned, he is saying that he has returned the file along with all.
On 17/8/2020, the petitioner to comply with the office objections raised on IA 1 of 2019.
Yes, madam.
Thereafter, an order is passed on 1/9/15/10/2020 with paper publication in respect of.
I have took notices to all the respondents. All the respondents. Same parties in both the
Service of
cases.
Notice in respect of respondent number 1 to 6.
Yes,
By
ma'am.
way of paper publication in Kannada Prabha.
Yes,
Is
madam.
accepted.
Yes, madam.
Then.
That's the same parties in this next petition.
24 September 2021, what has happened?
So, the notices were served to all the respondents, madam.
What is this? This is arising out of which proceedings, this writ petition?
So this is arising out of the order passed by the trial court in the execution petition.
What did the court do?
See, the suit is for specific performance and along with the recovery of money. Recovery of money has been decreed before by the trial court. So against which nobody has filed any appeal. So thereafter, I have filed execution petition. In execution petition, so notices were served to the parties. The first time, the sale warrant along with the attachment was issued. So thereafter, after issuing the sale warrant and attachment, one objector R6 before hearing. Objector has filed application for recall the attachment warrant and also impleadment of her in the petition, which was dismissed. So thereafter, I have filed same application, order 21 rule 97 and order 21 rule 54, attachment and also issuance of warrant, which was allowed. So thereafter, so again she has filed application for similar application dismissed earlier, so which was allowed. So again, at which I have prepared this.
The registry, the execution petition number 44 of 2011 is dismissed from
So dismissed.
7/2019.
The point is, while I have filed a writ petition, the stay has not been granted. Issue notices to the parties.
What did you do to restore that 27/2019 one?
So
Execute, now this writ petition arises out of a some order passed in the execution.
yes, madam.
That execution petition itself is dismissed on.
Dismissed because the stay has not been given here.
It's not that. Now if.
My lords, it has been dismissed.
Execution petition itself is not there.
Yes.
Then this order also, no order can be passed.
No, madam. It's after recalling this order, automatically it is open, madam, because they did not give any time.
Have you questioned the dismissal order dated 27/2019?
Yes, madam. So I have not.
You have not questioned it.
See, thereafter, what happened, madam? So during pendency, so I did not know. See, which was dismissed because of stay has not been granted several times.
Then what is to be done?
So then they after recalling this order, automatically that opens, madam.
Be automatically. That is an independent order. Dismissing your EP is an independent order which has to be questioned. How can this be a consequential order, and by virtue of this order, it would be restored?
So without granting any stay, so they will,
Whatever is the reason, whatever is the reason for the trial.
so several applications were filed for granting time because of the writ petition pending here, madam. The trial court did not agree. So therefore,
What did you do then?
so I am pressing this writ petition.
By pressing this, EP won't be open. EP execution petition will be opened once an order is passed, setting aside that order. Unless and until that is questioned, what is how can an order be passed in this now when nothing is pending?
So even after this order goes, I will file fresh execution petition or to reopen that.
Will an order be passed by this?
So
court?
because this.
EP itself is not, EP
No,
itself is not in
so
existence.
when I am not appear before this during pandemic, during pandemic.
That's not the.
That is true, my lord. During pandemic,
You are mixing two
the
issues.
cause list has not been issued under the.
Let's have the clarity. Don't mix up so many issues. Now you filed, you are aggrieved, but you are before this court questioning an order passed in the EP in respect of a particular application. What is order impugned before this court?
So this court has not been granted any interim order, my lord.
What
That is,
interim order, impugned order? What is the impugned order in the, before this court?
so that is allowed the impleading application as well as the
You are
attachment.
aggrieved by an order passed by the trial court in the EP proceedings,
Yes, ma'am.
allowing some implead petition.
Yes, ma'am.
Now that is pending before this court. In the meantime, your EP itself is dismissed.
Because
And not because whatever is not the reason, what remains is EP is not at all in existence. Unless and until that EP is restored, when it is not there, this writ petition has to be dismissed. As there is no EP proceedings are pending.
because of
This are all the orders that are
Subsequent-
culminated
because
with
of
that order.
because of this subsequent order, so I can't move. The subsequent second time order, kindly see the entire orders as well as the application which I have filed before here.
This interlocutory application and dismissing the EP are two different orders. Unless and until the EP is restored, no order can be passed by this court. And this court can't wait for you to file an application to restore an EP that was dismissed on 27/2019. And after 5 years.
Unless this.
No, that is not consequential. It is not consequential. Why it is dismissed? Because you have not pursued it.
So because they did not grant time because of this.
So what to do? It is an order which has to be questioned. Please come.
So
This
2
writ
weeks
petition
time,
is filed.
2
on
weeks time may be granted.
One nine
at
one
least.
three one. This writ petition is
Ah.
filed in the year 2018.
So otherwise,
Questioning an order. Where is impugned order?
Annex
number.
K, dated 24, dismissed for default on 24/9/2021. So impugned order at Annexer K. K ink page 87 maybe. Common order.
Agreed with the order passed in.
So that at
Order
least
passed on an application at order 21 rule 97
2
and
weeks time may
98.
be granted.
That is
so that
section
at
151 CPC. Dated 24
24/9/2020.
24/9/2018.
21 year. Madam.
21.
24/9/2021, this court has
Not this court, Mr. Counsel, I'm referring to the impugned order.
impugned order dated 24/2/2018, madam. Sorry, madam.
24/8/2018.
24/2/2008.
24/2.
2018, the petitioner is before this court. Initially, when this matter came up before the court, on 1/9/2020, the petitioner was permitted to take out notice by way of substituted service by the next date of hearing. And by order dated 15/10/2020, the hearings were rescheduled. Later, by order dated 17/11/2020, paper publication is accepted. When this matter came up on 12/6/2024, as there is no representation on behalf of the parties, the matter was directed to be listed for dismissal. An order passed by the division bench is placed before this court, wherein it is observed that the execution petition number 44 of 2011, that is, in which the order impugned
Principal senior civil judge CJM
One
Kolar.
minute, 1 minute. 44 of 2011, in which the present impugned order is passed, is dismissed on 27/2019 for default. When once the EP itself is dismissed for default, the question of deciding these interlocutory petitions would not arise further. When it is dismissed in the year 2019, the petitioner has not taken any steps to get the EP restored. In that view of the matter, this writ petition also stands dismissed. Yeah. Both the matters, 12 and 12.1.
Please, permitted to take steps in the EP.
No, court need not, it's your.
Otherwise, the entire,
Why should, when you're keeping quiet from 2019, why should this court give you any liberty?
see, during pendency, so the R6 has been purchased. There is no any other property to the JDRs.
Lord,
So at
sufficient
least-
opportunity was given, but even.
No,
then
no,
they-
no.
At least to take steps against the EP, my lord. Otherwise, this court.
That is for you. Why should the court tell you that you should take steps?
Because of not granting the interim order, that so several times have took times and they have dismissal for default. The entire scope of the party can deprived, my lord.
So when it is dismissed for default, you will not question it. I don't think it's not fair. We can't make that submission.
Well, at least to
13,
take,
no, I will not, I'll not.
to take steps, my lord.
13. Yes.
The husband's petition.
Where is the statement of assets and liabilities?
My lord, I filed it. We filed it on Saturday itself, but cast list shows that it's not filed. I
You
just
filed
now
it on
went and
Saturday.
inquired.
Where are they?
She said that she'll put some documents we have filed, my lord, some photographs and
Non-filing
tax
of
returns.
statement of assets and liabilities before the court. by both the
Statements and
parties.
assets and liability, we are not filed, but we have filed documents of written income tax returns and some photographs of her luxury.
No, when we say refer to statement of assets and liabilities means.
My lord, that is with the
that is
in DB
state-
case, they have filed it, my lord.
No,
Uh.
when the court says statement of assets and liabilities means. assets and-
I'll obtain it, your lordship, may kindly call it next time. It is in the DB case they have filed. We
Let
have
us see.
filed.
I have to bring to this court knowledge one thing.
I am
Kindly
not
see,
appearing in DB case, that's how I don't
Yes.
have copy.
kindly see.
What is the order
The
improved?
order dated 23/9/2019. An interim order was granted.
Where is that?
At-
Page number?
This is the first, I think,
I'm looking at first. That
in
is
this case, my
71.
lord,
Put 13,
4774 of 2019.
yes.
Yeah, the impugned order is that 15,000 maintenance amount has been granted. And in this writ petition, in the first date of hearing, an ex parte order was made, asking the petitioner union to deposit 9,000 per month regularly, including arrears. It was passed in the year 2019. Till date, even single rupee has not been deposited.
You didn't
No,
file
it's,
EP?
it's false, my lord, that's false.
You didn't
But
file
what-
EP? EP.
I am not appearing in the trial
But,
court.
You
Yeah.
means the.
I got it. I believe they have not filed EP.
my
Then
lord,
they have to
my
file-
learned friend may not be aware of it, they had filed an EP, we have paid up to date money, my lord. That money
Whatever
has
it is,
been
that
paid.
That
Yeah,
has to be
money is
taken care
being
of by the
paid,
court.
he may not,
Now, what is the income of the husband?
In,
30,000 rupees.
my lord, kindly
He
see.
works, my lord, it's my
He's the
petition.
petitioner.
I'm the petition. I'm the
Who has
petition,
filed this?
husband's petition.
Husband's petition for
For
the
the wife.
divorce, for divorce.
No, you're the, who,
Well,
Who
I
is
think
the
we have to switch.
petitioner?
Huh.
please come that side.
Okay. Because there was no place at that time I occupied.
Hmm. What is the income?
My lord, husband is working as a part-time principal. He is getting a salary of 30,000 rupees. He is also pursuing PhD. The respondent is also a M.Tech. She is a well-qualified lady. She works with the multinational companies. Earlier, during the time they lived together, the petitioner had provided her, made her a registrar of the college. She was not happy with the salary and, the administrative work. She left the job and at that time only she joined MNC. That time itself, her salary was 75,000 rupees. My lord, like section 24,
Has she not filed a statement of assets and liabilities before the court?
in DB case, they must have filed, my lord. I'm not aware of, I don't appear in
It's
DB
Not
case.
in DV case,
this
when
is
an
in
order
writ-
is passed in MC.
True,
It
my
should be filed in MC. Why would it
MC,
be
it
filed
was
in
not
DV?
filed, I think, my lord.
Both of you have not filed.
No,
Then you continue to pay that, let it be decided.
no, my lord, she is working, she is earning more
Now,
than the
without
husband.
Filing all that,
I will try, I'll obtain a copy. and
not
produce.
before this court. Why should the court
But
do
there
all
was
that
a
labor?
direction that it should be filed. I tried to contact my
Let
client
the
and.
court do that work, not this court. Please
No,
come.
my lord, your lordship may kindly see, there are judgments which says this, an interim maintenance under section 24 is not for a party to lead a luxurious life. It is only for sustenance.
That the court will decide, provided as per the law laid down in Rajneesh versus Neha, you have completed the formalities, which you have
I
not
will
done.
verify, my lord, I'll
Not
verify and
verify,
produce.
do it before the
We have
court
already
below.
produced some documents, your lordship may
Not
kindly see.
before this court, do it before the court below. And let, till such time continue to
My
pay.
lord,
And
again, my lord, they cannot look into that order. This court has to look into the order, whether that order passed is
We'll set
proper.
aside this order. We'll set aside this order and you lead your evidence, let the court pass
Yes.
orders.
Your lordship may
The
also direct,
husband
it's a
is-
2016 petition expeditious
The,
disposal also.
the present writ petition is filed, agreed with the order passed in I number 3 in MC number 2147 of 2016, whereby the wife, whereby the court had granted an amount of rupees 15,000 as maintenance to the wife. It is a case of the husband that she's earning an amount of, earning salary of
75,000.
more than 75,000 per month. And according to the petitioner, he's only getting a salary of 30,000 per month. The code below,
15,000 has.
1 minute.
15,000 and 25,000 litigation expenses.
The code below had directed the husband to pay 15,000 per month as maintenance and 25,000 to the respondent towards the, to the wife towards the litigation expenses. In the entire order, this court perused the entire order. In the entire order, there is no mention about the statement of assets and liabilities of the parties. What is the financial capacity of the parties? Nothing has been discussed by the court. In the considered opinion of this court, unless the statement of assets and liabilities are placed on record, the court cannot come to a just conclusion. In that view of the matter, this court deems it appropriate to set aside this order and direct parties to file their respective statements of assets and liabilities before the court below. The court has already granted an amount of rupees 15,000 for maintenance and 25,000 towards the litigation expenses till the order is passed by the court. This 15,000 will be in subsistence.
My lord, your lordship, there is a stay order to pay 9,000 rupees.
There was the stay order was granted by this court on which date?
On 23/9/20.
On
23/9/2019.
23/11/2009.
2009.
2019.
23rd September 2019.
23rd September 2019.
19.
2019 till now, the husband shall pay the amount at the 9,000 per month, and from now till the application is decided, it is 15,000. And the
Expeditious
parties are
dis-
at liberty to, the application shall be disposed of within a period of 2 months, and thereafter, even the pending MC, which is a very old one, shall be disposed of as expeditiously as possible. Yes.
Your lordships kindly, serial number 28. In the after,
There is a specific note on the cause list that the mentions can't be at 2:30. At
I have
1:30.
got some personal inconvenience in the afternoon, Your Honor. I have to
Which
take
matter?
28, my lord, serial number 28. WP 13-684.
Yes.
On 20th or 22nd, it may kindly be taken.
Why such a long adjournment?
I will be out of station till Tuesday around 16th.
Then we
Correct.
will have it on 18th. Pose this matter on 18th.
Very well.
Because
Settled.
it counts for the petition.
Serial
So
number
please
47.
don't start, all of you.
Yes. Personal.
I have taken consult of the respondent advocate. Instead of 16th, kindly have it on 18th. Yesterday is 14th matter.
The matter which is not there in the list, take it, and now we have to change it.
So,
But
so
the matter
sorry,
is not even before the court.
Yes. I beg apology.
No, how will it be signed? How will that be granted without there being before the court? Please tell the court.
Yes,
The petition is not before the court.
I
No, you say something, I say something. On what?
it is my mistake, my lord. It's my mistake.
Get that writ petition, and then we will adjourn it to 18th.
Yes,
Tell her.
please. Much obliged.
Yes.
My lord, there is an emergency personal inconvenience. Serial number 47, filed an memo for non-representation.
Filed
The memo for non-representation. Petitioner or instructed us not to represent. So hence our file is, it may be taken on record.
You filed a memo for?
Non-representation.
Hmm.
So it may be taken on record now.
What is that memo for
The
non-representation?
client have instructed not to represent.
Then you have to file a retirement memo. Is it not? Giving all the particulars, just like that, he'll not tell you something and you can't tell the court. Unless and until a proper application is filed. Do it. Yes. Repetition is allowed. Yes. Call the person. Yes, what do you say?
And for the applicant, first respondent on issue. Kindly tomorrow.
The only issue is the court said that no gift deed is filed to show that he is interested and is a representative of the
Applicant-
deceased.
Applicant is not a legal heirs of
Huh?
the, legal heirs of the deceased.
Hmm.
My question.
Simple reason why it should be kept pending unnecessarily. We'll ask the court below. No, the sale deed that gift deed is filed before this court. Let it be considered. And they should be pleaded as LRs. Then let that order be passed by the court. Looking at whatever you
yes.
want to tell the court, please tell the court. Where is the order page number?
Page number 20,
Keep it in the cover.
page number 20,
Huh?
page number 20 onwards.
Page number 20. Agreed with the order passed in miscellaneous number 103 of 2010. By the second additional district judge Tumkur dated 19th March 2016. The legal heirs of the deceased plaintiff.
Appellant in this.
That
in
is
the
a,
appeal-
he's a
appeal-
plaintiff,
Plaintiff,
deceased plaintiff,
based on gift deeds, my lord, is legal.
the
based on-
deceased plaintiff. The court, by way of order impugned, had set aside the amendment. But as far as impleading the LRs of the deceased was concerned, court has given a finding that the proposed legal representatives are not the natural legal heirs to the deceased appellant, but they are claiming under the gift deed as grandchildren of him. Their father is alive, they cannot claim as a legal representative of the deceased. It is also stated that, it is also observed that where is that the court said that this is not filed?
Gift deed not filed, third pair, the 15 para, third line. Gift deed in their favor. This is chicken.
No. They did not
Produce, first line, proposed.
prima facie did not produce any document that a gift deed is executed in their favor. Accordingly, the same is dismissed. Agreed thereby, they are before this court. Learned counsel for the petitioner submits that the grandfather of the petitioners had filed a suit for declaration and
Declaration.
injunction,
Yes.
and the same came to be dismissed.
Dismissed, yes.
Dismissed. Thereafter, he preferred an appeal. During the pendency of the appeal, he died. And it is also their case that a gift deed was executed in respect of the suit scheduled properties by their grandfather in their favor by registered document dated
29/4/2008, my lord.
29/4,
Two separate gift deed, one 29/4/2008.
29/4/2008,
One in favor of the first petition and third response.
by way of two separate documents. The grandfather died on
Died on 29/4, gift deed. Passed away on 18/5/2010.
passed away on 18/5/2010. It is a case of the petitioner that, in fact, the gift deed is available and the court has not has not looked into the same, nor the stage of considering the same has not the court has not considered the same, and without considering it, dismissing the application, permitting the petitioners to be impleaded as in LRs is bad. Next, then counsel for the respondent submits that.
Provision also not correct.
Huh?
They have filed application 22 rule 2.
They submitted that
Both are-
the provision under which the application is filed is not the correct provision of law.
Correct, Roger.
And the court below is right in dismissing the application, even on the ground that the gift deed was not placed. And as the father is alive, they cannot be termed as legal representatives. And no grounds are made out seeking interference with the said order. I invite the counsels on either side for the material on the court. The undisputed facts are that these petitioners are the grandchildren of the deceased plaintiff. He died during the pendency of the appeal. According to these petitioners, the grandfather has executed two gift deeds dated 29/4/2008. 29/4/2008. The only ground on which, so abutment is set aside, but they were not permitted to come on record as LRs, is that the said document is not filed. This court finds the same before this court, where the court had, they filed the gift deeds before this court dated 29/4/2008. Hence, this court, without going further into any of the technicalities, deems it appropriate to set aside this order. And the court below, looking at the gift deeds that are filed, shall pass appropriate orders within a period of 2 weeks in the date of receipt of the copy of the order. This appeal of which year? RA?
2009.
This is an old
2009,
appeal.
2009.
This is the RA is a old petition, the old appeal. The same shall be disposed of as expeditiously as possible, but not later than 6 months. Yes, next. Where is the petitioner?
It's continuously absent, my lord, petitioners.
It is for dismissal.
Please, my lord.
Give that. This court, 1 minute. In this writ petition, Seven 12/2020 has granted interim order. Thereafter, that is extended, and at the request of the petitioner, the matter was adjourned on several occasions. And office objections were also not complied with. On 18/7/2024, as there is no representation on behalf of the petitioner, directed the matter in the caption for dismissal. Today also the matter is called, there is no representation on behalf of the petitioner, and the writ petition is dismissed for non-prosecution. Next. When you should come? It is 15 is already disposed of yesterday itself, but of oversight the same is posted.
Yes. Give the docket. When the matter came up on 21/3/2021, as there is no representation on behalf of the petitioner, the matter was directed to be listed on 3/4/2024. An interim order was extended. Again, on 3/4/2024, at the request of the petitioner, the matter was directed to be listed on 18/4/2024. And in the meantime, the and steps to be taken, petition was directed to take steps, or else the petition against respondent number 2 shall stand dismissed. And when the matter came up on 4/7/2024, as there is no representation on behalf of the then counsel for the petitioner, the matter was directed to be listed for dismissal. Today, also there is no representation. See, dismissed for non-prosecution, both 16 and 16.1. And the matter came up on
petition, seal number 16, connected.
you appear.
Yes, madam.
Call
Madam.
16. Yes.
Madam, 16 is same.
Yes.
Respondent number 2, madam. 18/4/24 is process, madam. Respondent number 2 ಗೆ process ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು. ಸೇಮ್ ಇದು 80 ನಲ್ಲಿ ಸೇಮ್ ಅಡ್ವೊಕೇಟ್ ಅಪೇರ್ ಆಗಿಲ್ಲ, ಅವರೇನೆ ವಕಾಲತ್ ಇದನ್ನ ತಗೊಳಕ್ಕೆ ಸೇಮ್ ಪಾರ್ಟಿ ಅದರಲ್ಲಿ ಇರೋದು. ಸೀಲ್ ನಂಬರ್ 18/18/21 ಸೇಮ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2. ಯಶೋದಮ್ಮ.
Now, first writ petition, 8818/2021. What has happened in that? Isn't it ripe for hearing now?
Kindly pass for senior adapting portal number 20 minutes. Kindly pass.
No, if by the end of the day, if this matter is not already this court has dismissed, because now you have again
No, my
come.
lord, same lawyer is 1888, 18, same R2 ಗೆ same lawyer, my lord.
That he is saying.
Respond number 2 ಗೆ ನೀವೇ same ಹೇಳಿದ್ದೀರಾ.
For whom? Or to same lawyer?
Same 88/18/21. Same lawyer.
Ask your senior to come and argue. Let him say all this.
Kindly pass.
And if he doesn't come, I'll dismiss it before raising. He has to be here.
Kindly pass.
Yeah. 16, short, pass over. Yes.
17.
Yes, 17. Give that. As there's no representation on 1/7/2024, this matter was directed to be listed for dismissal. Today also, there is no representation on behalf of the petitioner. It appears the petition is not interested to pursue the matter. Pose this accordingly dismissed for non-prosecution. Next. Yes.
Judgment and decree, your lordship directed.
What is this petition about?
My lord, judgment that is repeats my lord.
Notice is served on the respondents?
Yeah, yes, please, madam.
Give it.
Judgment that repeats my lord.
This side so that you don't have to come. Yes.
Suit is 1/4 declares an injunction.
filed by
This is for injunction.
for declaration and injunction.
Declaration and
Yes,
injunction.
same are decreed by the trial court.
You are the,
I am now judgment debtor. The decree order has
you are the
filed-
defendant in the suit.
Yes.
Hmm.
Decree order has filed a present execution petition. In the said execution petition, the decree order has filed the IA number 10 for police aid. After hearing, trial court allowed the IA and directed police to help the court, bailiff to execute the delivery warrant. The court, has filed a report stating that without the assistant surveyor, property cannot be identified. Assistant survey is very much essential because in the decree, proper only survey number is mentioned, but no boundary is mentioned. Without boundary, it is not possible. The survey number mentioned in the decree is entirely different from my decree. In the guise of executing decree, decree order execute my property. Hence, the court has filed a report, but the trial court refused to appoint a court commissioner or a surveyor to assist the bailiff to execute the warrant, my lord. Hence, I filed this.
Please come to the implement order.
Page number 27.
27.
Yeah, operating cost.
Let's read from the beginning.
From the beginning.
Whether this order dated 3/6/2017 is questioned?
No, madam.
Page
No,
number
madam.
20. 3/6/2017, page number 20, bottom. Whether this order is questioned?
No.
Where you said that the property cannot be identified and they are interfering with your property
yes,
and a
yes.
surveyor is required.
Yes,
That
yes.
application is dismissed.
Apply this way because due to.
You have
power-
not questioned it.
No, because due to power, yes, I could not
Yes.
balance it.
Yes.
Your lordship kindly see page number
We'll
20.
go after that, one after the other. No, that earlier order, the judgment debtors have filed I number 4 under so and so, seeking to appoint the court commissioner to survey and demarcate the suit petition scheduled property and property bearing survey number so and so, contending that they are in possession and enjoyment of the house property constructed in so and so, and not in suit petition so and so, and there is dispute with regard to the property and its ownership. However, this court, as per order dated 3/6/2017, has dismissed the said petition. Yes.
Yes.
Yeah, thereafter, court bailiff visited the spot. He has submitted a report stating the assistant surveyor is very much essential.
Where is that?
It's your page number 29 in Kannada language. Typed copy at page number 30. Below 18/11/2022, deliver warrant written unexecuted as Amin's report and placed.
What is the date of this report? 18/11.
11/22.
When is this order passed?
Prior to that.
Then what is the relevancy of this to this?
No, because without assistant, Ami.
No. There was no occasion for the court to look at this before passing this order.
No, this order, IN order passed prior to the report. Thereafter, prior to the report.
So
Thereafter,
what is wrong with this report?
report wrong,
No.
because wrong, the court bailiff sought the assistance of surveyor, but court refused to assist appointed surveyor.
No, if this is the report of the surveyor.
Yes,
Much
no.
after the order passed by the
Yes,
court.
yes.
Why should the court look into this?
No, without the property become my property is bearing server
No,
number.
you should know that this is a whole issue. It is not that you are not an objector, you are a judgment debtor.
Yes,
The
madam.
similar stand you have taken before the suit, you have before the first appellate court. Both the courts have negated your contention
Yes.
and has decreed the suit.
Yes.
The very same contention, you are not, you can't take it now.
My humble.
Your contention is, you are not interfering or you are not residing in his property.
Yes.
In the suit schedule property, but you are staying somewhere else.
Yes.
That is your case.
Yes.
Now, when the same stand was taken during the course of arguments before the trial court said, unless and until there is a pleading and proof, these kind of arguments cannot be considered. And on the similar line, appellate court has also confirmed it. Now, in execution proceedings, how can you take the very same plea?
No, my humble request before the court, only upon the surveyor identifying a property because there is no boundary.
Earlier, when
Your
there-
lordship
no,
very
no.
well aware.
Earlier, please understand. Earlier, by order dated 3/6/2017, such a relief which is sought by you was
Yes.
dismissed by the court.
Yes.
So how many days you drag on the matter?
No, I am not challenging order passed on 3/6/2017, but now the court has bailiff has submitted a report stating their surveyor assistance.
That is for the court. Whatever supposed to be done, court will do.
Without identifying property, one matter will be solved.
This is not the way, you drag on the
No,
proceedings.
I am not dragging. If surveyor is
If you
Yes.
really, that is your case, you would have questioned this 3/6/2017 order.
my lord, because due to poverty, they could not charge.
You
Even
have come to the court now.
now they could because due to poverty, they could not challenge before this honor court.
With these kind of tactics,
No,
the
no.
the decree cannot be frustrated.
I am ready.
You can't be permitted to go.
I am ready to cooperate the judge
Please
because
tell
one
the-
day a
please
surveyor
tell the court when your application for the surveyor was dismissed on 3/6/2017, what were you doing?
because due to I could not approach this honor court.
Poverty, ignorance of law, those can't be the questions.
No,
Then you waited till 2022.
no, because I know because finance.
As far as this order is concerned, while passing an order in a writ petition under 227, this court is concerned with this impugned order. What is wrong or right with the order?
I am only seeking this.
That is beyond the scope of this writ petition.
Requesting for only upon this taluk surveyor.
Basing on this, you file an application before the court.
Because already filed dismissed. Once again, it amount to residue.
What you can't do straight, you can't expect this court.
No, if your lordship direct me gives me opportunity, I will file necessary application before executive court.
Agreed with the order passed in I number 10. Under order 21, rule 96 and 97. That was section 151 of the CPC, whereby the court below had issued a delivery warrant against judgment debtors and also directed the PSI of Siddhapur Police Station to assist the court bailiff in executing the delivery warrant issued by the court. The judgment debtor is before this court. Learned counsel appearing for the
the judgment debtor submits that the plaintiff decree holder had filed OS number 85 of 2002 against the defendants seeking the relief of recovery of vacant portion of the suit scheduled property. The said suit was decreed. Against that, they have preferred a appeal, that is RA number 31 of 2007. And as per judgment dated 16/3/2012, the same was dismissed, confirming the order of the trial court. Against that, no further appeal was preferred. Thereafter, the judgment debtor had filed I number 4 under order in the execution proceedings. The judgment debtors have filed I number 4 under order 26 rule 9, seeking to appoint the court commissioner to survey and demarcate the suit scheduled property and property bearing survey number 195 of Mekkuru Hoskeri village, contending that they are in possession and enjoyment of the house property constructed in survey number 195/1 of the Hoskeri village and not in the suit petition property. And there is a dispute with regard to the property and its ownership. But the court had dismissed the same by order dated 3/6/2017. Land Council submits that again is the same. They have not preferred any, they have not assigned the said order. Thereafter, the present application came to be filed by the decree holder, seeking police assistance to the court by bailiff to carry out the execution proceedings and to deliver the suit property to the decree holders. The judgment debtors have filed their objections, stating that the decree holder, it is a case of the decree holder that whenever they wanted to, whenever the position was to be taken, there was obstruction by the defendant. As such, they require the police assistance. For that, the objections are filed by the judgment debtor, stating that the decree holder have not mentioned the date on which the judgment debtor have objected or resisted the visit of the court ameen or taking delivery or possession of the property. It is stated that the property is not identifiable and it is not the court commissioner who can identify the property, the court ameen who can identify the property. And without identifying the property survey numbers is extent, the warrant, if executed, it will lead to multiplicity of proceedings. Thereon, the court had allowed this application and observed that the order that is passed earlier in IN number 4 and under orders 26 rule 9, which is filed by the judgment debtor, came to be dismissed on 3/6/2017, seeking to appoint a court commissioner to survey and demarcate the land. The court observed that even after dismissal of the said application, the judgment debtor, without obeying the order of the court, but delivering the vacant portion of the property, have again obstructed the court bailiff in executing the delivery warrant. It is contended by the judgment debtor that the said application, judgment debtor, that there is a dispute with regard to identification of property, and without identifying the property, its survey numbers, extent and delivery warrant cannot be executed. The court has observed that the scope of inquiry in execution proceedings is very limited and court cannot go beyond the decree, and court cannot tinker its the findings of the court which passed the decree. the contentions that are taken by the judgment debtor cannot be decided in the execution proceedings. Had he been, as the similar contentions are advanced before the trial court as well as the appellate court, and if he is not satisfied with the judgment and decree passed by the court, the judgment debtor ought to have carried the same in further up in a RSA. The court has observed that in the suit, it is observed by the court that the said stand that they are residing in the house constructed in survey number 195-1 and not in the suit property. Such a contention was not taken either in the written statement or in the reply notice, and first time during the course of evidence, DW1 and DW3 stated the same. The court has observed that no amount of proof is helpful to a party who has not stated the same in his pleadings. Even the first appellate court has affirmed it. Considering all these aspects, and court has also observed that except producing the revenue documents, defendant has not produced any document to show that they are residing in the house constructed in survey number 195/1. And also, no document is produced that they have preferred an appeal against the order for the judgment and decree in RA number 31 of 2007. When it is the case of the defendant that he has been residing in the said property even before the suit is filed, nothing has been stated as referred to above in the written statement or in the notice. Considering all these aspects and the fact that the defendant is obstructing the execution of the decree, the court below had granted the police protection. Next para. Then counsel for the petitioner submits that the court, the Amin has written the delivery warrant unexecuted as Amin's report and written the unexecuted and he has provided to, he had prayed to provide a surveyor, which is on 18/11/2022. Basing on this, the land council submits that this order is liable to be set aside.
On submission, I am not certain because only appointed survey matter will be resolved.
The set aside, this writ petition is filed under Article 227 of the Constitution of India. The limited scope of this writ petition is look at the legality or otherwise of the order impugned before this court. If the delivery warrant itself is returned unexecuted and basing on the Amin's report, it is always open to the decree holder to move the court. And because Amin had given such a report, as far as this court cannot interfere with this order, as the court, considering the fact that on the earlier IA number 4 that was dismissed on 3/6/2014, the petitioner has not preferred any appeal. And repeatedly, as he is taking the very same grounds that were agitated within the suit and in the appeal, which are confirmed by both the courts, and no further appeal is preferred. The court below is right in passing this order, and this court finds no illegality with the said order. If any of the subsequent developments that are taken place, which are advantageous to the petitioner, he is always at liberty to state the same before the court below. Yes. Accordingly dismissed.
Petition in this case, my lord. But I am extremely sorry, my lord, I could not be present in the earlier occasion.
Notices are served or not served?
No, notice had to be ordered, my lords. It is for preliminary hearing earlier, it was registered on 1st of July.
Yes. What is this writ petition about?
But petition is not about granting of interim maintenance against the respondent. Not operative portion is at page number 20, my lords, of the writ petition impugned order. Respondent is direct.
You're for the husband.
I am for the husband.
How much is granted?
my lord, 15,000 is granted, my lords.
What is the income of the husband?
My lord, the husband, my lord, is an accountant, BCom graduate accountant working in Kuwait, my lords, for a private firm. Whereas, my lord, the respondent, my lord, was a MSc graduate, my lord, in lab technology. And my lord, she was working in Kuwait, my lord, earning 280 dinars, and my lord, about 78,000. My lord, she left Kuwait and landed
No.
in India.
No.
Please.
That will be considered once
Yes.
she enters
After,
her
my lord,
parents.
so it is on merit.
So what is now?
But now, my lord, so she claimed that she is unemployed. Lord, one cannot expect that, my lord, such a graduate, my lord, so working in a hospital remain, my lord,
The court is
therefore,
saying, now the stay would be granted on payment of
yes,
amount.
yes, yes, my lord,
So
I
those
will, my lord,
forgiveness at this stage will
Lord,
not go into.
please, please, my lord, I may, my lord, offer, my lord, 8,000 rupees, my lord.
When is the
Lord,
petition?
first January 5th, my lord, she filed petition.
January 5th of?
5th of 24, my lord, 2024.
So till now 7 months.
Yes, my lord.
56,000.
Please, my lord.
Please come. Land counsel for the petitioner submits that though the wife is educated and she was earning, the court had failed to consider the same as she is not entitled for maintenance and granted maintenance of an amount of rupees 15,000. Considering the submission of the land counsel for the petitioner, they shall be stay of all further proceedings on the condition that the petitioner shall deposit an amount of rupees 56,000 within 4 weeks from the date of receipt of the copy of the order and continue to pay an amount of rupees 8,000 as maintenance by 5th of every succeeding month. The petitioner is permitted to take out notice on the counsel appearing before the court below and shall file a memo to that effect. Post this matter on August 13th. A memo with regard to service of notice to the respondent shall be filed before this court on 9th. Either the memo is not filed, amount is not deposited, the stay granted by this court stands vacated without further reference to the court.
Apply.
Yes.
For respondent number 10 to 38, your lordship.
Where is that IA?
The
For
petitioner-
paper publication?
The petitioners have filed it. We are not.
Oh,
Yeah.
we will order this.
Your
Where
lordship.
is the IA? Huh?
Your lord.
Not mentioned. No newspaper edition not mentioned. No representation for dismissal on the top of the list tomorrow. Yes,
Your lordship, one humble submission.
counsel to the respondent is present tomorrow on the top of the list. Yes. Where is the counsel for the petitioner?
I'm for the petitioner.
You are for the petitioner. Yes.
To the respondent.
No. Yesterday, I spoke with the doctor, but from what he says is, in Nimhans, they have completely a special ward for the children who are mostly of this age. They have a school there. Right from morning to evening, there will be school and the teacher will be there, whatever or the curriculum or whatever is the syllabus, they'll be taking care of it. He says, under these particular facts and circumstances, absolutely it is not possible for the doctors to assess the child. And they say, they feel that according to the mother, she is doing well, she is doing in studies and all. They say these people will have a chronic effect on their lives. So that can't be the assessment. And she requires at any cost. And she has to go. They say that it's very much required for her. And that whatever the environment that is there, it would be, the girl would be liking it. It is not like what the mother expressed yesterday is like staying between. No, it is completely a different place where only the children will be there and they will have a regular school. And right from the morning till night, on all basis, they'll be having the assessment. And when the girl is constantly with the mother and under her supervision, it would be very difficult to elicit all the issues. That's what the Get it, I'll just pass over, tell the mother, we have to pass the order. Tell the mother. That she has to.
Much.
Yes. Next matter.
Appearing for the petitioners, my lord. Suit for specific performance. Sole defendant expired. This is a plaintiff's petition. Sole
Furnishing the
defendant expired.
Documents of NRs.
Have you given it to her?
I'm yet to collect their.
Why did you not give this information? When the sole respondent died?
My lord, the sole respondent died and I filed application to implead his legal representatives. One of his daughters had predeceased the sole defendant. Since the respondent appearing before my lords is a sibling, I sought for a direction for furnishing the details of that daughter who had predeceased the sole defendant because it's a suit for specific performance. Now that they're giving the details, I will file necessary applications to bring her legal representatives on record.
When she did, even before filing of the suit itself, she died.
Oh, no. Yes, you know, she died. We got to know that she has died by virtue of when legal representatives notice when
Yes.
it came
when-
as dead.
When?
Now that I have to receive that information, when she died and what we did.
Petition of 2016.
That is why I had no other option other than to file this application, and in the event they fail, I was to file an application under 22 Rule 4A seeking the court to appoint him as the defense for assisting his sister's claim.
What is this? Let us see before that. What is IA?
IA was for amendment of pleadings, my lord.
Let us see.
I had filed two IAs. This is an agreement that was entered into on the defendant number 4, my lords.
Suit for specific
Suit
performance.
for specific performance. On 26/12/1974, the defendant filed application under Form 7 under Section 48 of Karnataka Land Reforms Act to acquire.
26/12/1974.
Yes, and to acquire 21 acres of land in survey number 46 of BM Kaval, Kaval Gram Panchayat, Kengeri, Hobli. Thereafter, my lords, there was writ petitions filed challenging the amount of the extent of land that was granted to him. However, once the lands were granted to him in 2000, it was upheld that there was an extent of land that was granted to him. Therefore, in 2002, 26/3/2002, the plaintiff entered into an agreement to sell. That agreement, it was specifically agreed between the parties that the area of out of this 21 acres is not yet demarcated by virtue of survey. Once the area is demarcated, that schedule will be incorporated into the agreement, and that is the portion that will be sold. However, without disclosing that area has been surveyed, they remained silent. On notice, since they did not come forward for execution of sale, we filed a suit for specific performance. During the evidence of the suit for specific performance, it was learned.
Which year?
OS of 2005. 4/4/2005 is when the suit is filed.
4/4/2005.
Suit is filed. And in 2005, 17/8/2005, they filed the written statement.
When was the written statement filed?
17/8/2005. In the written statement, their only denial is the very execution of the sale agreement, but they do not speak about the boundaries or about the extent or any of that. During evidence, my lord, it was learned that there was a survey that was conducted, and by virtue of the survey, the boundaries had gotten fixed. Therefore, we filed an application, IA number 17 and IA number 20. These are two writ petitions connected with each other. One IA was to amend the schedule in the agreement and another IA was to amend the schedule in the suit plane because by virtue of the survey, the boundaries gotten fixed and we were entitled for that specific boundaries.
Which year is the amendment?
Amendment application, my lord.
So whenever a fact is stated in the evidence, that would be the reason for amendment of plain. Yes, amendment which year?
Amendment application, IA number 20. IA number 20 was filed on 27/4/2016.
Very early.
That was, we were not the parties to the survey that was conducted.
So
Only
please
during
come.
the evidence, the survey report was
Please
bought
come.
and marked.
Please come to the impugned order. Where is the impugned order? Page number. Well.
Apologies, my lord. You referring to my notes and.
Page 12 is the order.
Yes, yes, I am just taking out. Without impleading the legal representative, it would be,
If the court is allowing your writ petition, it should be impleaded. If the court is dismissing, doesn't matter, that can be done before the court below also. So the court has to see whether there is any substance in your writ petition which is pending from 2016.
very
Once the court
apologies,
will-
I've got my trial court records, but I've not got the writ petition order copy.
Please argue tomorrow.
My lords,
Please
I
argue.
will argue them.
We'll see is a case where notice to respondents is required. Yes. Yes, next. Tomorrow. This is also next, the top of the list after that. Yes.
The respondent plaintiff.
Yes. Who appears the petitioner?
I'm appearing for the.
Yes.
There are two writ petitions.
Yes.
One is a writ petition filed against rejection of the application filed under Section 8 of the Arbitration Conciliation Act.
Yeah.
And the other writ petition is filed against rejection of the application seeking amendment of the written statement. Lords, I suggested, my lords, of course, he expressed this inability. I said that if the amendment is to be considered, then I will withdraw the application for amendment so that we can go before the same authority and conclude the matter. But he said that it's a central government undertaking. He'll not be in a position to concede for it.
Now, what is this maintainability of the appeal?
Lords, Section 8 application against that, this is passed by the commercial court. Earlier, a view was taken that all the orders which is passed by the commercial court has to be challenged, by the court has to be challenged in the appeal. But now, my lords, as things stand, Section 8, my lords, if the proceedings are culminated, then ultimately, my lords, parties will only be relegated to the arbitration proceeding. There is an arbitration clause. Arbitration clause is admitted. In the written statement, there is a specific stand taken that this is an arbitrable dispute and the parties will have to be relegated to arbitration. The trial court only takes a view that by referring to a coordinate bench judgment of the Honorable Court in Tinplate's case says that before filing the written statement, you should have filed an application seeking reference to arbitration.
You filed written statement.
The written statement
Touching
itself.
upon the merits of the matter. That's the one.
The
Rider is there.
The Supreme Court now says, even if you do it along with the written statement, it is not a bar to consider it under Section 8. Now, what happens in
So
respect
what we
of?
do is, please, in this 23,
Yes.
please come to the impugned order so that it will be easy
Lords,
for the court.
If your
to
losses were to
understand what
take,
is
you know,
ordered.
the WP number 1133 of 2020. Judgments.
The first writ petition, 1187?
Lords, 1133 of 2020 is the writ petition in which the application seeking reference to arbitration under Section 8 has been rejected.
Next matter.
The next matter, my lords, is WP number 1187.
No, first is 1187, second
Yes.
is 1133.
Yes.
Hmm.
If I can take 1133 of 2020 first, my lords.
Yes,
if
where
your
is
lords will
impugned order?
permit. Lords will find the application is at page number 63. What would be relevant for your lordship's consideration, my lords, is from page 65.
This commercial suit is of the year 2013.
Yes.
And when is this application filed by you?
Lord, this is an application which was filed in the year 2020 itself.
2020.
2019, 2018, I stand corrected.
2018,
Yes,
after 5 years.
yes, my lords.
Yes.
Page 63, my lords, is the order. Application, your lords, will find at page 54. Twenty-three to 2018. Page 52. Send the order.
Yes. What is impugned order in the other case?
What's impugned order on the other case is rejecting the application seeking amendment.
1187.
Yes,
Page number?
page 31st. Page 75. Reason starts at page 79. Produced only the order. Additional issue is not produced.
Yes.
May I request your lordships may kindly take WP number 1133 of 20 at the first instance. 1133, which is the writ petition challenging the dismissal of the application under section 8. Lords, this was a suit which was originally filed before the City Civil Court, Bangalore. And the written statement was also filed before the City Civil Court, Bangalore, and subsequently in the year 2018, the matter stood transferred to the commercial court. These matters were all transferred. But when the matter was pending before the City Civil Court, Bangalore, the written statement was filed, which is at page number 33. Your lordships were to take page 33, my lords, in this writ petition.
Yes.
This is the written statement. The first sentence, the opening sentence, my lords, in the written statement is, in view of the arbitration clause, plaintiff is liable to be returned. Arbitration clause operates as a prohibition and thus the plaintiff cannot maintain the present suit. Arbitration clause in the MOU dated 18/3/2010 is herewith extracted. Lords, having said this, if your lordships were to take the plaint itself at page number 28, para number 28.
Page number?
Page number 28, para 28.
This was filed, written statement was filed on.
Lords, this was filed in the year 2016, yes. 18/3/2016.
Yes.
The plaint itself refers to the existence of the arbitration clause at
Yes.
para 28.
Hmm.
The plaintiff submits that there is no arbitrable dispute between the plaintiff and the defendant, since the defendant has admitted his liability categorically in the letters dated 15/5/2012 and 17/7/2012. Therefore, clause 11 of the arbitration clause of the MOU is not applicable. Suit for recovery is maintainable. This was the plea taken. Now, if your lordships, despite having said this at page number 33, lordships may kindly also have a look at paragraph number 28 at page 44 and 29.
Yes.
The averments made in the para that there is no arbitrable dispute between the plaintiff and the defendant is emphatically denied is false. It is reiterated that the defendant has never admitted the liability in the alleged letters dated so and so. It is submitted that clause 11 of the MOU dated 18/3/2010 is an arbitration clause. Hence, it is quite clear that the plaintiff cannot file the above suit. Dispute raised in the above suit shall be arbitrable dispute, and the same shall be dealt with the provisions of the Arbitration and Conciliation Act 1996 and the rules framed thereunder. On this count alone, the suit is liable to be dismissed. On this ground, the court has no jurisdiction, as admittedly clause 11 of the MOU is clear, which was the jurisdiction of the Honorable Court. Then para 29, in view of the arbitration clause, plaintiff is liable to be returned. Arbitration clause operates as a prohibition and thus the plaintiff cannot maintain the present suit. Further averment made in the plaint that the Honorable Court has jurisdiction to entertain and try the above suit is denied as false. There is an arbitration clause MOU which is sparse. Now, after having said this, an application had been filed seeking framing of an additional issue. Lords, which your lords will find at page 52, my lords.
Yes.
Lords, an additional issue is framed whether the suit is maintainable in view of the arbitration agreement. That is on 23/12/2018. May I just read this small portion of the order, my lords, at page 52. PW1 present, advocate for defendant praised time, prayer rejected, cross of PW1 taken as nil. Advocate for defendant number filed IA number 6 under order 14 rule 5, copy served, heard. Advocate for defendant has taken up the contention, the written statement regarding the arbitration clause. Hence, application is allowed. Additional issues framed. Additional issue framed is regarding the maintainability of the suit in the teeth of the arbitration clause. After 23/2/2018, when this application has been allowed, then, my lords, the application has been filed saying that this is a suit which cannot be pursued with in view of the arbitration clause. Now, my lords, I will not trouble your lordships because your lordships have already gone through the orders which is passed by the commercial court. But what I need to refer to your lordships, my lords, is at page number 69.
Yes.
Anand Gajpati Raju's case is referred. And then Magma leasing matter is referred. Lords, there if your lordships were to see what is important, my lords. Magma leasing is a judgment which said that if there is an arbitration clause and if the other side comes and opposes, then sections 8 is a suo motu power that court has to exercise and refer the parties to arbitration, because if this exercise is not undertaken, then there will be no use of introducing this 1996 Act. In that, my lords, your lordships may kindly see, in the middle of the paragraph, after section 8 is extracted, an analysis of section 8 would show that for its applicability, the following conditions should be satisfied. There exists an arbitration agreement. Action has been brought to the court by one party to the arbitration agreement against the other party. The subject matter of the suit is the same as the subject matter of the arbitration agreement. That the other party, before he submits his first statement of substance of the dispute, moves the court for referring the parties to arbitration, and that along with the application, other party tenders the original arbitration agreement, duly certified copy thereof. Further, the advocate for the plaintiff is also relied on ILR 2002, that is India Lease Development. Para 4 is extracted where it says that the section makes abundantly clear that the application for referring parties to arbitration can be filed at any time, but not later than the first statement of substance of the dispute is filed. Therefore, an application section 8.1 can be filed at any time prior to or at the time of filing the written statement. Let's kindly mark that words. It is either prior to or at the time. So the defense can be raised simultaneous with the fact that the defense is raised regarding the matter to be referred to arbitration. Further, learned advocate has also placed judgment of the High Court in Thin Plate's case, in which the Honorable High Court of Karnataka has held that the application section 8 must be filed prior to or at the time of filing the written statement. If such application is filed after the written statement is filed, after the suit is set for trial, it is nothing but dwelling on the merits of the case by relinquishing the right to file an application section 8. The above proposition of law, the Honorable Apex Court in the High Court, is aptly applicable to the facts of the case on hand. As noted supra, defendant appeared in the case on 25/11/2015 to set aside the ex parte order against him was allowed in 2016. Ex parte evidence of plaintiff was recorded prior to IN number 4 of the defendant. Subsequently, defendant has filed his written statement on 18/3/2016. Issues were framed on 4/1/2017, was set for cross-examination. Defendant obtained adjournments of so and so. Subsequently, since defendant failed to cross-examine PW1 on 27/2017, an order was passed by the court to the effect that cross-examination was taken as nil, posted the case to 23/8/2017 for the defendant. 23/8/2017 application I number 5 of Order 18 Rule 17 to reopen the case and recall the witness. This was allowed on 500. Such reopening of the case and recalling was made again. The defendant obtained an adjournment by filing an adjournment application for cross of PW1 on 23/2/2018. Request was made for adjournment of cross. And then again, the orders was passed to the effect that the cross of PW1 was taken as nil. Subsequently, the case was posted on 23/7/2018 for evidence of defendant. Again, on 23/7/2018, defendant obtained adjournment for his evidence by way of filing the adjournment application on I number 7. Subsequently, on so and so filed an application I8, Section 8 of Arbitration Act. Since the defendant has filed his application during the course of trial, the suit, that too, when the suit was postponed for recording of the evidence, the application I number 8 is not maintainable. Now, the only question is this, my lords. If I have taken the plea which attracts Section 8, filing of an application itself is necessary for the purposes of invoking the jurisdiction under Section 8 of the Arbitration Conciliation. The reason why I am submitting this is the court proceeds on the basis that Section 8 would not be considered because this is filed at a point of time when the trial is under progress. The trial court does not make a reference to the fact that it was already stated in the written statement that this is a matter which is squarely covered under the arbitration clause, based on which this entire transaction is being referable to that memorandum of understanding, the MOA, and therefore the arbitration, the parties will have to be referred to arbitration. This is precisely a question, which came up for consideration before the Supreme Court. What's in Anand Gajpati Raju's case, may I just refer this judgment, Para 8, my lords, of this judgment. Paragraph number 8, my lords. Lords, para 7, I'll just read because that's how the Supreme Court frames the question to be answered. A further question arises whether the court in these circumstances obliged to refer the parties to arbitration, and if so, with what effect? In the matter before us, arbitration agreement covers all the disputes between the parties in the proceedings before us, and even more than that, as already noted, the arbitration agreement satisfies the requirements of Section 7 of the new Act. The language of Section 8 is peremptory. It is therefore obligatory for the court to refer the parties to arbitration in terms of their arbitration agreement. nothing remains to be decided in the original action or the appeal arising therefrom. There is no question of stay of the proceedings till the arbitration proceedings conclude and the award becomes final in terms of the provisions of the new act. All the rights and obligations, remedies of the parties would now be governed under the new act, including the right to challenge the award. The court to which the party shall have recourse to challenge the award would be the court as defined under clause E of subsection 2 of the new act, and not the court wherein application is made. The application before the court in section 8 brings to the court's notice, kindly mark this, my lords. An application made before a court under section 8 merely brings to the court's notice that subject matter of the action before it is the subject matter of an arbitration agreement. This would not be such an application as contemplated in section 42 of the Act, and court trying an action may or may not have the jurisdiction to try the suit which starts with or be the competent court within the meaning of section 2E of the new Act. We therefore allow the application and would refer the parties to arbitration. No further orders are required in this appeal and it stands disposed of accordingly. Lords, two things which I just wanted to highlight, Lords, with reference to Anand Gajpati Raju's case. Number one, I have already read your Lords, Lords, because it was extracted in the judgment, which is paragraph number 17 of this judgment, where he says that the other party, before he submits his first statement of substance, moves the court for referring the parties to arbitration. This is essentially, my lords, what is the language employed? We have to bring it to the notice of the court, and this is what is to be done because there is an arbitration clause which is in existence. Number two, what is that the court needs to do is what is contained, my lords, in para 8, where it says, language of section 8 is peremptory. It is therefore obligatory for the court to refer the parties to arbitration. This is number one, my lords. The second judgment which I want to refer to this probably, my lords, answers the issue which I wanted to frame for myself to be answered before your lordships. Para 14 and 15 may I draw your lordships' attention, my lords. 14 and 15. Basically on the same principles in Anand Gajpati Raju's case. Lords, I'll just read para 14, Lords, so that it will get a connect to para 15. The defendant in the present case also, as in Arth Jetani Supra, has neither in para 3 of the preliminary objections nor in the prayer clause of the written statement sought reference of the parties to arbitration. However, I am unable to in section 8 find any requirement for application to seek a reference to arbitration. Section 8 requires a party to arbitration to only intimate to the court that the action before the court is the subject matter of an arbitration agreement. The duty to refer the parties to arbitration is thereafter to the judicial authority, and merely because such an obligation has been imposed on the judicial authority does not mean that the party invoking the arbitration clause has to seek reference to arbitration. As long as a party to the proceedings before a judicial authority invokes arbitration, not later than when submitting the first statement on the substance of the dispute, that is enough to bring the bar under section 8 to the play, and the judicial authority court then ceases to have the jurisdiction. The Supreme Court in the case of Anand Gajpati Raju has held that the language under section 8 is peremptory and it's obligatory for the court to refer the parties to arbitration in terms of the arbitration agreement. The next question for consideration is whether the making of an application under section 8 is necessary or the plea substantially of section 8 in the written statement suffices. You know, this is essentially what I want to argue before the lordships. Though subsection 1 of section 8 merely talks of if a party so applies and when can also be in the written statement, but subsection 2 and 3 of section 8 do mention an application under subsection 1. However, in my opinion, the legislative changes contained in section 8 of the 96 Act as from section 34 of the 1940 Act is not indicative of an application separate from the written statement being necessitated to be filed for invoking the arbitration agreement between the parties. In fact, even in Arth Jetani Supra, it has been held that the reference under section 8 of the parties to arbitration can be made if the written statement itself contains a prayer for referring the disputes up to for arbitration. However, Arth Jetani, to the extent it holds that there is to be a specific prayer for reference to the with due respect of the judgment in Arth Jetani, is contrary to the mandate under section 8. Section 8, as above said, merely requires a party to the action before the judicial authority to bring to the notice of the judicial authority that the action brought before the judicial authority is the subject of an arbitration agreement. As long as the same is done in the written statement, mere absence of a prayer or use of the word seeking reference to arbitration cannot come in the way of the obligation of the judicial authority to refer the parties to arbitration. Then, of course, para 16 is essentially, my lords, what I wanted to campaign before the lords, because this is essentially where the court says the court had to consider what would be the effect of taking a plea in the written statement that this is an arbitrable dispute. In page 33, I have referred to your lordships, and para number 28 and 29, I have referred that there is a specific plea which is raised where I have stated that the dispute will have to be referred and the court will not have the jurisdiction. One more judgment, my lords, of course. Sir. Of Justice Sikri, as he then was, sitting as the presiding judge of the Delhi High Court in Para 7, in the case of Eastern Medicate. Para 7, my lords. Something more or less similar to the one which is now before your lordships. No doubt, written statement has been filed. However, in the written statement, the very first objection taken by the defendant is that the suit is barred under the provisions of the Arbitration Act, and the arbitration clause contained in the invoices is reproduced by the defendants. That even the written statement is filed strings attached by challenging the maintainability of suit in view of the said arbitration clause. Therefore, in such circumstances, the first preliminary objection of the defendants contained in the written statement can be treated as an application of Section 8 of the Arbitration Conciliation Act. It is more so when the plaintiff has filed the suit, has no objection for the matter to be referred. Of course, this sentence becomes necessary because there is an admission of the arbitration clause in paragraph number 28 of the plaint, which I read to your lordships. So therefore, my lords, I just want to say this, my lords. There is some procedural error which even the trial court committed. Earlier, I was placed ex parte. After I was placed ex parte, the plaintiff had filed the affidavit evidence, which was at an ex parte stage. Then issues were framed on 4/1/2017, after which no evidence was adduced. There was no evidence which was adduced. But the trial court posed the matter for cross-examination, notwithstanding that the issues were already adduced. Nor is there any mentioning in the order sheet saying that the evidence which was adduced prior to that time, because once the ex parte is set aside, the clock goes back to the time when I am entitled to file the written statement. Written statement is taken on record and the issues are framed. After the issues are framed, no fresh evidence has been adduced. No affidavit is filed after the issues are framed. And then the additional issue is again framed, as I refer to your lordships, my lords, on 23/2/2018 at page number 52, which I refer to your lordships. Lords, even on the factual aspects, there is some procedural irregularity with which the court is proceeded with. To say that because I have followed with this procedure, therefore I don't want to consider the application may not be factually correct, because this is essentially what has happened. But on a principle or on the first principles, the moment in the written statement, the first sentence is that this is a suit which is not maintainable. Parties are required to state their rights.
Why the defendant was contesting the matter all through?
My lords, that's the reason why I said there is no contest from the stage of filing the written statement. The first contest comes by filing an application seeking amendment of the issues.
They have filed so many applications before the court.
For recalling of the witness.
So if it is your case that there is an arbitration clause and all these judgments which you are referring to.
Lordships.
When the court has not considered the same.
Yes.
On the technicalities like this, whether that any specific plea is taken, whether that should be treated as an application under Section 80, and all those circumstances, the judgment arrives.
Lordships.
The court said, once you say in the written statement that there is an arbitration clause, then that can be done.
Yes.
So the whole purpose of relegating the parties to the arbitration, what is a mode of adjudication before the arbitrator? The whole.
Lords, what
thing is
happens?
towards,
Yes.
In a quick way.
My lords, I would say it this way, my lords. It will be quicker is one aspect of the matter. Once the arbitrator decides, then the right of appeal gets shrunk. It is not the same as like a commercial appeal which we bring under Section 13 of the Act.
No, for that, a defendant who has submitted in all ways himself to the jurisdiction of the court.
That's the reason.
The judicial time of the court has been wasted for
If
such
your
a long
lordship feels,
time.
my lords, that this is because if your lordships were to see, my lords, the language employed in Anand Gajpati Raju's case, paragraph number 8, the moment it is brought to the notice of the court, then it is the duty of the judicial authority.
When
Now-
once the court is proceeding.
Lords, now that's the reason why I said, my lords, the court takes note of the arbitration clause which has been raised as a defense only by raising an additional issue at my instance, which was on 23/2/2018. Lords, the court has not looked into what is there in the written statement, and if
That
it
point
wants
of
to
time
proceed.
also,
Yes.
even at the part, that point of time also, you never agitated that issue that the court has no jurisdiction, but in fact, you wanted the court to frame an additional issue
Lords,
that there is an arbitration.
there is an
clause.
arbitration clause. Lords, the moment Lords, what we said, there is a defense which is
Why should there be
specifically
an
raised
issue?
under order. Lords, now it is if the court is accepted that there is already a play in the written statement raised initially, even before the contents of the plaint is adverted to in the written statement saying that there is an arbitration clause. For the first time, the court has an opportunity to look into it only on 23/2/2018.
No, absolutely, there is no dispute on that proposition
Lots
and
of-
all the judgments speak so.
Yes, my lords.
Now, we have to, looking at the facts and circumstances of this case, a suit that is filed in the year 2013, which at one stage or the
That's the
other,
reason, my lords,
like-
my lords, this is essentially because I certainly would have known, my lord, that this certainly would crop up and I need to answer this. Therefore, I wanted to say this. If your lordships were to permit the written statement to be amended, I will not press this application. Lordships may give a direction that we should cooperate with the trial within 3 months. I'll conclude the proceedings.
So it's an offer to the court.
My lords, I'm because it's more in the nature of a plea bargaining, my lords.
And order 7, that application, you can't set up a new case by way of an amendment.
My lords, absolutely no new cases set up. My lords, if I were to read the written statement contents, absolutely nothing new has been set up. I will take your lordships to that order. We have not said anything new. My lords, what happened since there was an arbitration clause and this plea was raised, and that is what has been stated in the affidavit supporting the application under Order 6, Rule 17, saying that since we had filed this written statement specifically raising the plea of the arbitration clause, therefore it was not fully elaborate. But what we wanted to say, it is there in the written statement. Now these are all the essential facts, which because it is a case of accounting. Lords, now they say that according to us, under the MOU, these are all the invoices raised and these
Let
are all
us
the.
look at your IA for amendment of written statement.
Lordships.
What is that you wanted to amend?
Please, my lords.
It is in 1133?
This will be in 1187, my lords.
Yes.
IA number 12 for amendment.
Page number, where is the affidavit?
57. Page 57, my lords. Page 57.
Yes.
May I just take your lordships, my lords, what actually has been spelled out is the facts emanating from the transactions relating to the MOA, nothing more. I'm not taking any defense which is away from this MOA. Just read the affidavit, my lords. It's a very detailed affidavit filed. But sometimes the ends of justice could easily be handled because if they are in a position to show any part of my written statement which goes beyond the scope of the dispute.
No, please come to para 39. Is it part of the agreement that you're saying?
Para?
Para 39 at
Of
page
my,
59.
yes, my lords, para 39. Yes, my lords, this is relatable to the same transaction. Lords, whatever I am referring to is only the same transaction.
Why is that this is required when everything is on record?
My lords, this is relatable to the very same transaction. The reason why this is required is we have given the explanations. My lords, what happens? This is a transaction. At every stage of the transaction, what transpired, how much was the shortfall, how the invoices were raised, how the invoices were short written, and why the payments were made in this manner is what is explained in this written statement. Everything will be borne out of the records, my lords, which I'll be in a position to produce and demonstrate. My lords, I'm not saying anything which is beyond the scope of the memorandum of agreement. If your lords were to see, my lords, the affidavit which has been filed at page number 65.
Yes.
Lords, paragraph number 3 and 4. After service of summons, I entered appearance and filed the written statement by specifically contending that a preliminary objection that in view of the arbitration clause, plaint is to be returned and the plaint is not entitled to present the instant case by extracting clause 11 of the memorandum of agreement and also stating that para 35 of the written statement that I would reserve liberty to file additional written statement in due course if warranted. The whole object of filing the written statement was that the written statement is filed only with reference to correctness or falsity of the contentions raised by the plaintiff to indicate the existence of a dispute, which will come within the purview of an arbitral dispute under the arbitration clause in the memorandum of agreement. The other facts that has not been stated, as the first and the foremost contention had been raised that for which I had sought for reference to the parties to arbitration
We'll ask
subsequently.
Lanka. Yes.
Now, the honorable court has rejected the application based on my statement of objections, which you'll also still find at page 69 of the papers. And this application was filed in the year 2019. After section 8 was rejected, several applications were filed to recall my witness. Cross-examination was not done. I have prepared a list of dates and events to show how.
Please pass on that.
Yes.
Take that.
Now, in the objections, we said that all these aspects were much before the suit came to be filed when the transactions took place. It was open to him to urge them in the written statement which was originally filed. And when in the first paragraph, though they raised the question of arbitration, they have gone on the merits of the matter, merits of the claim made by the plaintiff in the suit for recovery of about 46 crores, and dealt with all the points urged in the plaint. Now, all these matters which are sought to be urged by way of amendment, they were all much before the transaction took place or at the time of transaction took place. It was within his knowledge, something which is not that it was within his knowledge, but in the affidavit, because the trial had already commenced, he had taken time to cross-examine PW1, not cross-examined. Also, matter was posted for his evidence. It was not done. Section 8 application, so many applications were filed, and matter was prolonged. But what is required is there was some due to some due diligence, want of due diligence, as required under the provision once the trial has commenced. In fact, my learned friend made a comment. After the issues are framed, there was no evidence, but we said that same evidence will remain. It is open for him to cross-examine PW. And several opportunities were given.
There is no such order to that effect, because if I just looked into the order sheet straight away without any submission being made, because the stage after the issues are framed is already prescribed under the schedule to the Commercial Courts Act, which is essentially importing the provisions of the CPC, which says it should be posted for admission of the documents which is to be exchanged, because this stage never came about in the proceedings. In a commercial suit, there is no question of the matter being posted to evidence. First, there is a interrogatory
before it was sent to the commercial court. This was all happened.
That's the reason. No, after the matter came to the commercial court and the issue is framed, once the issues are framed under the commercial court, the first thing which is required to be done is parties will have to be given the responsibility of admission and denial of the documents. There is a prescribed procedure. Now that procedure is never undertaken at all, because if they wanted to say there is no order to the effect that the PW1's evidence which was led prior to the stage of.
I'll point out in the list of dates,
Commercial Court Act.
Just to clarify the position. On 17th March 2014, the defendant was placed.
If the written statement is allowed.
Yes.
What is the prejudice to the plaintiff?
The amendment is allowed.
Amendment or written statement?
If the amendment is allowed. The prejudice is, it is a reopening of the whole matter. My evidence is already over. And he himself has taken time to cross-examine me several times. And I was discharged also on several times. Several applications came to be filed to recall me.
All these transactions, whatever by virtue of this amendment is sought to place now on record, are not the admitted transactions?
Because we have stated in our plaint as to where he has failed in his obligation under the MOU. And how our claim has been determined, all that is the part of our plaint claim. And he has responded to that. Now, this comes in the year 2019.
No, what are the new facts that he is stating in the
new facts statement? Is this all an afterthought? Where kindly see the amendment application itself.
So according to you, all these facts are very much in his notice?
Yes.
And he has not stated.
And now in the affidavit, there must be some reason why he was not able to plead this earlier. That is what the Supreme Court has said time and again. And you can't, I mean, file the amendment application as and when you like. Like it, the matter was before the amendment to the Civil Procedure Code. Now, my submission to your lordships is that these are all things deliberately to file, I mean, protect the proceedings, as your lordships have seen. First, section 8 goes, recall goes, everything goes, 19 this comes as a last resort. And in my objections, you will also kindly see at page 69.
Yes.
May I draw your lordship's kind attention to para 11 at page 72.
Yes. Yes.
The defendant filed I number 12 for amendment of the written statement on 27/8/19, seeking to add paras 36 to 48 after para 35 of the written statement. It is submitted that reading of the said amendment disclosed that the same relate to the incidents which happened much before the suit was filed. And apparently the defendant was aware about the said amendments. However, in the supporting affidavit, there is no statement in terms of proviso to Order 6 Rule 17 CPC. Since in the above suit, the trial commenced 5 years back and nearly 4 years have passed after the defendant appeared in the suit and filed his written statement. Now, therefore, now then, just because he has filed the application for amendment after all this, I mean, historical events, now I don't think this is a bona fide application at all. And in para 12, it is submitted that in the proviso to Order 6 Rule 17 CPC, it is mandated that no application for amendment shall be allowed after the trial has commenced unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of the trial. In the affidavit in support of I number 12, there is no statement laying the foundation that in spite of due diligence, the defendant could not plead in the written statement already filed. Proposed amendment is neither necessary nor adjudication of the suit, and also the same are not, as I submitted in the plaint, there are letters written by him admitting the claim. And we made it very clear, if there was a dispute, then certainly the matter was open for other proceedings.
No, this IA, please come to the chronology of events.
Please.
This 21/7/2018, IA 8 and Section 8 of the arbitration that filed with the
18.
defendant came to be dismissed.
Yes.
I filed the additional.
That was not questioned
No, it is questioned now.
in this, sir.
Yes, yes, now it is questioned. You also may kindly see the delay also there.
Yes, yes.
Then several dates for cross-examination, additional issue, they applied. Now it is for them to, I mean, establish their additional issue burden is on them. Cross-appeal will be not done. Then 21/7/18, ISO and so, conciliation filed, it was dismissed on 3/8/19. And 19/8/19 case posted for defendant's evidence, not done. Then 27/8/19 case posted for arguments. Earlier also, when he was ex parte, I had already filed, the matter had gone up to the stage of arguments.
You are relying on any judgment?
May I please, lordships?
You are relying on any judgment? Please pass on.
One of the earliest rulings in 2008, 5 SCC.
Yes.
May I request your lordships to kindly come to
Para number
para number 11 and 12
11 and 12.
at page 121.
Yes.
In order to find out whether the application of the defendant under Order 6 Rule 17, amendment of written statement is bona fide and sustainable at this stage or not, it is useful to refer to the relevant provisions. Then this rule was omitted by the so and so. However, before the enforcement of the Code of Civil Procedure so and so, the original rule was substituted and restored with an additional proviso. The proviso limits the power to allow amendment after the commencement of trial, but grants discretion to the court to allow amendment if it feels that the party could not have raised the matter before the commencement of the trial in spite of due diligence. It is true that the power to allow amendment should be liberally exercised. The liberal principles which guide the exercise of discretion in allowing the amendment are that the multiplicity of proceedings should be avoided, that amendments which do not totally alter the character of an action should be granted, while care should be taken to see.
On that aspect, no
Yes, it's all
judgments are
there.
required.
Para 12, with a view to shorten the litigation, the speed up the trial of cases, Rule 70 was omitted so and so. The rule has been on this statute for ages, and there was hardly a suit or proceeding where this provision had not been used. That was the reason it evoked much controversy, leading to protests all over the country. Thereafter, the rule was restored in its original form by amending so and so, and a rider in the shape of the proviso, limiting the power of the amendment to some extent. The new proviso lays down that no application for amendment shall be allowed after the commencement of the trial, unless the court comes to the conclusion that in spite of due diligence, party could not have raised this matter before the commencement of the trial. But whether a party has acted with due diligence or not would depend upon the facts and circumstances of each case. This would, to some extent, limit the scope of amendment to the pleadings, but would still vest enough powers in courts to deal with the unforeseen situations whenever they arise. But no unforeseen situation has been stated in this case. Then kindly come to para 15 on the next page.
No, as far as that proposition
That
is
proposition,
concerned,
exactly. Now,
yes.
in the affidavit,
Yes,
there must be some statement.
that in spite of due diligence, they could
No,
not bring
due
this case
diligence
to
that
court.
should be explained.
Yes.
Using the words, phrases is not sufficient,
Yes, yes.
and he must do that. So under Article 227, when the trial court has applied the right principles, in my respectful submission, this is not the case for interference. In such a protracted manner, after, 2013, we are in 24, 11 years. And it's a public sector company where it has, entrusted certain work and paid him also. And he has failed to carry out all his obligations. It is on these grounds, my submission to your lordship says, this is not a fit case for interference. Then one other recent amendment, ruling is 2019. One paragraph. Para 7.
Yes.
Leave to amend may be refused if it introduces totally different, new and inconsistent case or challenges the fundamental character of the suit, challenges the fundamental character. The proviso to order 6 so and so virtually prevents an application for amendment of pleadings from being allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, the party could not have raised. Then therefore the burden, therefore the burden is on the person who seeks an amendment after commencement of the trial to show, in spite of due diligence, such an amendment could not have been sought earlier. There cannot be any dispute that an amendment cannot be claimed as a matter of right and under all circumstances. Though normally amendments are allowed in the pleadings to avoid multiplicity of litigation, the court needs to take into consideration whether the application for amendment is bona fide or mala fide, and whether the amendment causes such prejudice to the other side, which cannot be compensated adequately in terms of money. Now, the trial court has detailed its, in the order as to how the defendant, after appeared in the case, how the defendant has conducted himself. Therefore, on just grounds, the trial court has rejected the application. In my recent submission under Article 226, this is not a case where this honorable court could exercise supervisory powers. And it's always there. Now, there are certain provisions where if he is prejudiced by the final judgment, he can always raise those things in appeal, if at all, because now this is a regular suit in commercial court. And we have been, want to see the progress of this matter. This is pending before this honorable court since the year 2020, I'm sorry. So therefore, the proceedings are stalled now by virtue of the interim orders granted by this honorable court. And there is no just reason at all for this honorable court to, allow the application for amendment at this distance of time. After all the historical thing in my list of dates, kindly see how he has juggled in the proceedings.
I've seen that.
Going forward, coming backward, and again making applications, and again, these are all tactics which the litigant wants to adopt to see that the case doesn't progress. And that is certainly causing prejudice to the
Yes,
plaintiff.
yes,
Therefore, both the cases deserve to be dismissed in my submission.
yes. It
Lords,
reflects.
just 2 sentences, So far as my section 8 application is concerned, apparently there is no arguments as such because section 8 is already raised in the written statement. There is no judgment to the contrary which has been relied upon by them to show that this plea could not have been raised. Number 2, the procedural irregularity which I pointed out still remains because after the evidence is recorded at the stage when the matter is placed ex parte, even if it was before the suit, then order 14 Milords stipulates as to what needs to be done after the issues are framed.
That is not the issue, I think, before.
Now, the reason why I said this is additional issue is also framed This was also framed only on 23/2/2018. It is after that, the application for section 8 and subsequently the amendment is filed. So whereas the amendment application is concerned, para 6, 7 and 8 very elaborately stated as to what necessitated the amendment in the present circumstances. Para 6, 7 and 8 very, very elaborately stated that since a plea had already been raised, that there is a arbitration clause and the parties will be referred to arbitration. There is a denial of all the contentions that has been raised by specifically stating that we are going to raise the defense at an appropriate time because it was then before the civil court. And thereafterwards, it is already stated that these are all the facts which are completely germane to the transaction which they are referring to. I am not trying to make out any new case. I can understand if there is some other case which I want to try to make out from this written statement. It is not their case that it changes the fundamental nature of the trial itself. It will never. Because they say, in the nature of this transaction, there are 20 invoices and you are required to pay this much. I say, out of these 20 invoices, this is how transaction has taken place. This is how the invoices are underwritten and we are required to pay so much. This is essentially the written statement which is now presented, my lords, for amendment. Nothing more is stated. It looks elaborate because every single transaction has been dealt with in extenso. Other than that, my lords, there is nothing more which is said. So therefore, my lords, I respectfully submit that in the event if your lordships were not to accept section 8, the written statement at any rate has to be allowed. But section 8, my lord, since it's an obligation on the court, as Anand Gajpati Raju puts it, it is the peremptory requirement of the courts to ensure that section 8 comes into play in all circumstances. That is my respectful submission. I'm grateful for lordship's hearing in the matter.
So only section A, if the written statement does not touch upon the merits of the matter and raises a question of maintainability, saying that there is only arbitration clause, then my lord, there is a difference, lot of difference. Here, the exhaustive para-wise, in the written statement, they have traversed our plaint averments. That means to say that they have covered each and every plaint allegation in the written statement. Now, therefore, if the amendment is allowed, then what happens is, which is not part of the pleadings, then again, I may have to respond to it, depending upon their contentions. And this is a never-ending process. And having applied for recalling PW1, now they cannot say that fresh issues ought to have been framed. Yes. And at their instance, a maintainability issue has been framed. Let them establish that. Yes. If that is the case, then my suit goes. That's a different issue. Now, having filed a comprehensive written statement, there is no need for amendment.
Just one sentence I wanted to add, I know it is not a proper practice, but written statement means, the moment I say it's a written statement essentially means I have to counter what has been said in the plaint. That's how even the courts have dealt with. My lords, grateful for the hearing.
There is the maintainability issue.
Agreed with the orders passed in I number 8 and
may I seek your lordship's excuse, my lords. I'm grateful.
I number 8 and agreed with the orders passed in I number 8, which is filed under section 8 of the Arbitration and Conciliation Act, and I numbers 11, and that is to cross-examine that I number 2 filed under order 18/17, read with section CBC to recall the order dated 23/2008 and permit to cross-examine PW1, and IA number 12 filed under order 6/17, where to request a prayer is made to amend the written statement whereby the court below had dismissed all these applications. The defendant is before this court. Agreed with orders passed in I number 8, WP number 1187 of 2020 is filed, and against the orders in I number 2 and 3, I number 11 and 12, WP 1133 of 2020.
W187 is preferred against dismissal of WP number 1187 is preferred against dismissal of IA number 11 and 12.
No,
W133 is preferred
okay,
against.
1133 is filed against dismissal of IA number 8 and 1187 is filed against dismissal of IA number 11 and 12. The facts of the case are as these two writ petitions arising out of the same suit, both the writ petitions are disposed of by way of a common order. The respondent herein had filed OS number 1677 of 2013.
Yes.
OS number 1677 of 2013, seeking recovery of money. Where is the plaint?
Plaint is annexure A.
Page number, I am looking at WP 1133.
Plaint is at page number 11, annexure A. Where is that page 30?
The suit is filed on the file of the city civil judge at Bangalore. The original OS number 1677 of 2013, seeking the relief of recovery of money, recovery of a sum of rupees 46 crores, 60 lakhs, 60,546.
6 lakhs. 46 crores, 6 lakhs.
46 crores, 6 lakhs, 60,546 with interest at 18% per annum. It is the case of the plaintiff is a central government undertaking. It is their case that the defendant has been maintaining the business relations with the plaintiffs since 2010. They've entered into a memorandum of agreement dated 18/3/2010. And the defendant has also offered guarantee dated 18/3/2010 for the payment of dues to the plaintiff in pursuance of the transactions conducted by him. And as per the memorandum of agreement dated 18/3/2010, the plaintiff and the defendant entered into between the plaintiff and the defendant for pursuing the trade opportunities in the Indian market as well as international market for various goods and commodities through joint jointly pursuing various opportunities identified by both the parties. Iron ore was identified as a commodity to begin with. Then the plain discloses about the several transactions taken between the place and according to them, the defendant has to pay an amount of rupees so and so. That is that refers, and accordingly, they filed the suit. In the suit, the defendant has appeared. When did he file his written statement?
On 18th March 2016.
The defendant was placed ex parte as he failed to appear before the court in spite of service of notice on 17/3/2014. Thereafter, PW1 was examined. Exhibit P1 to P37 were marked. And on 7/1/2015, the plaintiff had filed the written arguments. Then on 18/2/2016, the defendant has filed the wakalat and also had filed an application to set aside the ex parte order. On 18/3/2016, filed the written statement wherein he had stated about the availability of the arbitration clause and also touching upon the merits of the matter. Then on 4/1/2017, issues were framed. On 27/2017, the case was posted for cross-examination of PW1. And on that day, the cross-examination was not done by the defendant. On 23/8/2017, an IA was filed to recall PW1 and the same came to be allowed. On 21/10/2017, the cross of PW1 and it continued on 21/10/2017. It was posted on 21/10, 22/11, 16/1/2018. And on all those 3 days, the cross-examination of PW1 was not done. Then on an application filed by the defendant on 23/2/2018, an additional issue was framed regarding the maintainability of the suit in view of the arbitration clause framed on the IA of the defendant. Then again, the matter came up on 27/4/2018 for the cross of PW1. Even on that day also, the cross-examination was not done. At that point of time, the 3 applications that are impugned before this court.
No, 21/7/18, section IA8 under section 8 was filed. After the cross-examination was not done on 27/4.
Then now both of them at a time, now they have filed the writ petition against that.
Writ petition is filed now, but on
On
21/7/18.
21/7/2018,
Yeah.
the IA that is filed under section 8 of the Arbitration and the Conciliation Act filed was dismissed on 3/8/2019. Against that, they filed the writ petition 1133 of 2020 when?
On 14th of January 2020.
On 14th of January 2020. Then the case was posted for defendant's evidence on 19/8/2019. Again, it came up on 27/8/2019, again posted for the arguments. On
20th August 2019,
On 20th August 2019,
they advanced the
the
case.
case was advanced and IA number 9 and 10 were filed to recall the order dated 19/8/2019 and to permit the defense to lead the evidence that came to be allowed. On 27/8/2019, the case was posted for defendant's evidence. IA number 2 is filed to recall the order dated 23/12/20.
I number 11, my lord, I number 11.
What is that?
I number 11 was filed to read.
IA number 11 was filed to recall the order dated 23/12/2018 and to permit defendant to cross-examine PW1.
Yes.
PW1. And IA number 12 is filed to amend the written statement.
Yes, yes.
Both these applications came to be dismissed when? These applications, IA number 11 and 12, came to be dismissed on
2nd January 2020.
7th January.
2nd January.
2nd January 2020. Then the plaintiff the defendant has come before this court, questioning an order in IA number 8, which was dismissed on 3/8/2019, and also this order where IA number 11 and 12 were dismissed by the court below. Learned counsel appearing for the defendant, learned senior counsel appearing for the defendant submits that when once they have filed the written statement and a plea was taken that the, that the, that there is an arbitration clause and the suit is not maintainable. No, when was it transferred to the commercial court? In 2018?
2018.
That in the facts, in the year 2018, the case was transferred to the commercial courts.
19 is it?
2019, 2019, the case was transferred to the commercial courts. What did you write? Maintainable, and the parties have to be relegated, the suit is not maintainable.
10-1-2018.
Huh?
10-1-2019 is when the suit is transferred to commercial.
10-1-2018 is.
19.
19. It is, the senior counsel submits that at para 28 of the plaint, I have specifically stated that there exists an arbitration clause covering the dispute on account of alleged admission. While filing the written statement and before entering into the minutes, the defendant has specifically stated that the nature of the controversy in the suit was arbitrable and the suit cannot be maintained on account of the existence of an arbitration clause. Even it is stated that even at para 29 of the affidavit or in the written statement, the same issue has been reiterated. The senior counsel had relied on the judgment of the Honorable Apex Court in case of P. Ananda Gajapati versus PDG Razu, reported in 2004, 4 SCC 539, and also another judgment of the Apex Court in case of judgment of the Delhi High Court, in case of Sharath B. Jagtiani versus Mrs. Edelweiss Securities Limited, reported in 2014 SEC Online Delhi 949, and another judgment of the Delhi High Court in case of Eastern Medikit Limited versus RS Sales Corporation and other, reported in 2006 SEC Online Delhi 626. Basing on these judgments, the senior counsel submits that the Apex Court in Ananda Gajapati Raju's case at para number 8 has observed that, extract para number 8. That the language of section 8 is peremptory and it is obligatory for the court to refer the parties to arbitration in terms of their arbitration agreement. And nothing remains to be decided in the original action or the appeal arising therefrom. Further, in the case of Sharath B. Jagtiani, which is referred to Supra, relying on para number 15, that
I have underlined that. It has been held that reference under section 8 of the parties to arbitration can be made if the written statement itself contains a prayer for referring the disputes for arbitration. And further, because section 8 merely requires a party to the action before a judicial authority to bring to the notice of the judicial authority that the action brought before the authority is a subject of an arbitration agreement. As long as the same is done in the written statement, mere absence of a prayer or use of the words seeking reference to arbitration cannot come in the way of the obligation of the judicial authority to refer the parties to arbitration. Basing on these judgments, and counsel submits that once a written statement is filed, and in that a stand is taken that there is existence of arbitration clause, the court ought to have referred the matter for arbitration. Without doing so, the court has dismissed this application filed by the plaintiff, filed by the defendant. It is submitted that when in response to IA numbers 11 and 12, it is submitted that the court has failed to follow the procedure as contemplated with the commercial courts. And close the evidence, when the court has closed the evidence by order dated 23/8/2015, they filed a petition under IA number 11 to recall the order. And also, they filed another petition under Order 6 Rule 17 to seeking amendment of the written statement. Then the senior counsel submits that by virtue of this amendment, they are not setting up a new case, nor they are introducing the new facts. And the facts which are between the transactions that are between the parties, they are elaborately mentioning about the same. Even if such an amendment is allowed, no prejudice would be caused to the defendant, to the plaintiff. It is stated that at para numbers which para of the IA senior counsel was referring? 7, 8, 9. About why you have filed this petition. It is stated that at para number
Your Lordships are referring to the affidavit in support of the IA for amendment.
yes. 6, I think. In para number 6 and 7, they have categorically stated the necessity to file this application and the delay that occurred. It is submitted that when the proposed amendment do not change the, when by way of the proposed amendment, when they are not introducing a new case and that do not cause any kind of prejudice to the respondent, to the plaintiff, the court below ought to have allowed the application. It is submitted that without considering all these aspects, the court had dismissed both I number 11 and 12. And it is submitted that I number 11, 12 and 8 needs to be allowed in the interest of justice. Next. Then counsel appearing for the respondent plaintiff submits that the company, the plaintiff is a central government public sector company. It is, the suit is filed in the year 2013. Right from 2013 till 2024, so many, several proceedings have taken place. Several applications were filed by the respondent defendant. He has proceeded with the matter. He has submitted himself to the jurisdiction of the court. And till they filed, till they filed IA number 8. By the time they filed IA number 8, stating that there is an arbitration clause and the parties have to be relegated to arbitration. For that, they have come up with several applications before the court. And at a prior point of time, they never took such an objection. And conveniently, they have been participating in the trial. Though several opportunities were given, they have never ventured to cross-examine PW1. One after the other, several petitions are filed to recall PW1. All those petitions came to be allowed. And then they come up with the present, the first IA number 8. When IA number 8 is dismissed in the month of October.
3rd August 2019.
Huh?
IA number 8 was dismissed on.
When the IA number, yes, I got the papers.
Please.
When IA number 8 was dismissed on 3/8/2019, then also they have not questioned the same and they kept quiet. Later, this IA number 11 and 12 is filed. One is to recall the order dated 19/8/2019, whereby the case was posted for defendant's evidence. Now they want that order to be recalled and they want to cross-examine PW1. And another application is filed seeking amendment of the plaint by introducing the facts which are very much in their knowledge, and they have filed this petition almost 3 years after they have filed the written statement. He submits that after the amendment to the CPC to order 6/17, if after the commencement of the trial, if any amendment is sought, they have to, the burden lies on the party to show, burden lies on the party to say that in spite of due diligence, such facts could not be brought to the notice of the court in the letter in spirit. He submits that all the transactions that he's referring to in this amendment, all refers to the transactions which have taken place much before the filing of the suit. And all those transactions are very much in the knowledge of the defendant. Just to protract the proceedings and with an intention, only with an intention to delay the proceedings, these applications are filed. Not only these applications, several applications which are filed. We are relied on the judgment of the Honorable Apex Court in case of Chandar Kanta Bansal versus Rajendra Singh Anand, reported in 2008, 5 SCC 117. Basing on this judgment, then counsel submits that the whole purport of the amendment to Order 6/17 is to shorten the litigation and to speed up the trial of cases. And that unless and until the theory of due diligence is approved, they can't be permitted to amend the pleadings, amend the written statement. And he has also relied on another judgment of the Apex Court in case of M. Revanna versus Anjama, reported in 2019, 4 SCC 332. Basing on these two judgments, then counsel submits that the court below had rightly dismissed the petition, and all these writ petitions are liable to be dismissed. And when the amounts runs into crores of rupees, which is due to the plaintiff from 2013 to 2024, that is for almost more than 11 years,
they have been protracting the proceedings and the writ petition is liable to be dismissed. Next. Having heard the counsels on either side, the material on record. Know the IAs that are impugned before this court as I number 8, which is filed under section 8 of the Arbitration and the Conciliation Act, and I number 11, filed to recall the order and to permit the defendant, the plaintiff, permit the defendant to cross-examine PW1, and an IA number 12 under Order 6, Rule 17 to amend the written statement. This court is very surprised the manner in which the arguments are advanced on IA number 8, on IA number 8. It is IA number 8.
That's arbitration.
On IA number 8. The defendant who has filed his written statement in the year 2016, though the averment with regard to the availability of an arbitration clause has been taken, then on the merits of it, he has filed the written statement. And he has not taken any steps, or he has not asked the court that the suit is not maintainable. The parties are relegated to the arbitrator. Without doing it, he had been pursuing with the matter. He has filed several petitions which are referred to in the preceding paragraphs from 17/3, 18/3, 2016 till 21/7, 2018. He was filing several applications. Several times the matter is posted for the cross-examination of PW1. The same was not done, and later additional issues were framed. He sought for additional issues to be framed on the maintainability of the suit. Thereafter, this application under section 8 of the IA 8 under section 8 of the Arbitration and Conciliation Act is filed. Very interestingly, when the court had dismissed such an application on 21/7/2018, he kept quiet without questioning the same. Then in the month of August, he files, in the month of, on 3/8/2019, to 21/7/2018, this was filed and it was dismissed on 3/8/2019. Then the matter is posted for the defendant's evidence on 19/8/2019. Then at that point of time, then from 19/8/2019 till 27/8/2019, on 27/8/2019, he files the present IA number 11 and 12. When these IAs are dismissed, then he comes up before this court, questioning that order also that is passed in IA number 8 under Order 8 of the Arbitration Conciliation Act. And these two IAs, 11 and 12. All the dates which the court has referred and the manner in which it is being pursued, it clearly indicates that only to, on one pretext or the other, the defendant do not want to proceed with the matter, and successfully having kept the proceedings pending from 2013 to 2024. These writ petitions are filed in the year 2020, and they are pending till 2024. He cannot, he can't, the applications that he's filing on one hand, and the other hand saying that the civil court has no jurisdiction. There is no connection between the several applications he's filing, and on the face of it, it is evident that there are no bona fides on the part of the defendant in pursuing the matter. The defendant is trying to take advantage of the process
and is coming up with different applications. When the matter came up before this court, Senior Counsel has submitted that if the defendant has no objection, shall I record that?
The plaintiff has no objection.
That's what, shall I record it?
Plea bargaining, that's what.
Whether the repetitions to be allowed. This is
No, shall I record it?
may not be relevant.
No, that's very much relevant, why not?
Disposing.
No.
Coming from a
the-
senior counsel.
The senior counsel said that let him accept for my amendment. I will proceed with the trial and within 3 months it can be done. That's what he said.
May not be relevant, my lord, but a time period may be.
No, it is not the question of relevant. It is very much relevant. It will definitely be against you. So what your submission should be is it shouldn't be recorded. Not relevant.
Not, it may not be.
What did you say? Not senior counsel. The judgments which the senior counsel has relied on pertaining to section 8 of the Arbitration and Conciliation Act. There is no dispute on that, and those judgments, application of those judgments to the facts of the case is not required for the reason that much water has flown from the application of section 8 as he has been contesting the matter right from the beginning. The whole purport of this Arbitration and Conciliation Act is to for the speedy disposal of the disputes between the parties. The purport is not that a person can contest the matter before the court, and after contesting for 10 years, suddenly he realizes and comes up with an application and can rely on all those judgments which are referred to, which can be, which will apply at the threshold. If this court, relying on those judgments and relegate the parties to the arbitration, it's a clear injustice to the parties, and that is not the purport of the Arbitration and Conciliation Act. Considering all, and when it comes to the amendment that is sought is about the facts which are very much in the knowledge of the defendant. And after when the matter is coming up for the evidence of defendant's evidence, when the plaintiff's evidence is already closed, at this point of time, they cannot come up with these kind of applications stating that those facts are not the new facts. It is not about introducing a new case. It is about what was the reason why this facts could not be brought to the notice of the court at the earliest point of time. For that, though it is stated by the senior counsel that there is a mention about this in so and so paragraphs, it is not stated why they wanted to state at this point of time. If by that the grounds which they have raised cannot be the ground for cannot be a ground for allowing an application under Order 6, Rule 17 after the trial has commenced and it is almost at the fag end of the trial. This court, both the writ petitions are liable to be dismissed, considering the fact that the manner in which the plaintiff, the defendant, has been protracting the proceedings and coming and filing these kind of applications, this court deems it appropriate to dismiss the writ petition with cost of ₹50,000 to be paid to the plaintiff within 4 weeks from the date of order.
Question.
Yes. Call that. What is that matter? Not 16. 16 is over. Oh, 16. Where is that? Post 16 on the top of the list tomorrow. Yes. Yes.
Discipline.
My lord, a submission, my lord. Overnight stay will be too much, my lord, for the child. My lord, the child is not.
It is about overnight stay is, she can't be continuously if she is under the supervision of the mother all the time without the doctors and all. It would be very difficult for them even to find out what is really happening.
Definitely, my lord.
There they'll have all the accommodation will be provided. It is not like they'll be staying on in the corridors or somewhere. It is in fact, for this reason, I spoke with the doctors yesterday of Nimhans. They said they have a complete setup where everything, even the parents, they will have a separate rooms where that can be taken care of. And for the daughter, she has to do it.
I consent to
Option
the
but to do
arrangement.
it.
I
Huh?
consent to the arrangement. I consent to the.
Yes.
My lord, can the 6 weeks be reduced to 3 weeks, my lord? The child is not even looking at the father. When we put
No.
her
Now the
into-
father is nowhere in the picture now.
It is just.
What
for
will
the child.
happen is,
Okay.
first 3 weeks, it will be mother and the daughter. And the next 3 weeks, it would be the father and the daughter. If not the father, then the grandmother. Grandmother would be staying with the girl. That is very much in her interest.
Paternal grandmother.
Paternal grandmother. Give that order, give that file. This court on 12/6/2024 had interacted with the parents as well as the girl, and particularly considering what has transpired on the day in the chambers where serious allegations were made against the father, particularly when there were people, including the advocates from the both sides were present, then this court felt it necessary to send to NIMHANS further counseling and also directed the hospital to send a detailed report to the registrar. And the report is placed before the court. Where is it? Was it in the chamber? I think it's just one single page.
My lord, one submission.
1 minute, Swarna. Yesterday, even at 7 o'clock also, that was there in the chamber. Huh? This is a rough copy. Then what happened? What are you saying?
My lord, about the school, the doctors at the Nimhans had mentioned that she can go to the school that she is currently going to and come back in the evening. That is what
The
they had
mother was
mentioned.
expressing that it's very difficult.
Indeed, my lord.
It is
but,
difficult. Then what will happen is, now again, mother and daughter will have some more time together for all this. The report was placed before the court where not the one. This is what's sent to Nimhans. The Xerox copy is there in the chamber. Hmm? You have it? The doctors have submitted a report stating that, from there you extract that state. Then after that, this court had interacted with the father, mother, and the child yesterday. You write the date. And even the doctors have informed them about the necessity for an admission for a period of 6 weeks. The mother had expressed her apprehension that the girl staying in Imhams for 6 months, 6 weeks, considering her age, and also it is stated that she is very good in her academics at this point of time. If she had to be there for 6 weeks, it might not be in the interest of the daughter, and she is ready for any kind of counseling therapy, which can be done on a day-to-day basis, and which they can every day go to the hospital. And considering the apprehensions that are expressed by the mother, this court had in fact personally spoke with the doctors at Nimhans. It is brought to the notice of this court that in Nimhans, they're having a special ward for the kids where they're providing all the facilities. The whole day, it will be like a school, and the children, like they can attend the schooling on the child's curriculum. The teachers would be teaching the child, and evening, like in the school, they can play. And also, one of the parent, it is stated that initial first 3 weeks, they want to have it with the mother in the evening, and for the next 3 weeks, it is with the paternal grandmother. And this court has specifically asked the doctor whether any other procedure is any other therapy that can be done, so that the girl can be with the mother without being an inpatient. They have clearly stated that, particularly in these kind of cases where there is a serious conflict between the mother and father, and when the child is particularly in the company is with the mother, and also considering the kind of allegations that are made against the father, unless and until they have unless and until she is as an inpatient and they have the observation, they cannot, no justice can be done. They very much felt that this is a case where the girl has to be admitted in her interest. When the mother said that she is very good in her studies, but that the doctors felt that basing on her education and her curricular activities or the extracurricular activities, that would not be the basis, because these kind of impact would be, they would not be knowing it immediately. Considering all this court is of the view that the girl has to be has to be admitted as an inpatient, and as per under the classes and everything, if it is required to bring it to the school authorities or for any other permission, this order shall be brought to the notice of the court, and the Nimhans, the hospital shall take care of the girl, and after 6 weeks, from when?
15th, Monday.
15th? Well, not 22nd, one more week, we have to.
Look, this will only exaggerate the.
Okay.
Guilty.
22nd, from 22nd, 6 weeks. 22nd. Hmm? 2nd September, 6 weeks. After 6 weeks, the report shall be placed before this court by the named hands. Both the parties shall adhere to the advice of the named hands, and they are not permitted to act as per their own whims and fancies. Post this matter on what is it, said, 2nd, post this matter on 6th, under the caption Part 3rd. Yes. September.
One indulgence, Your Lordships directed for the mother and the paternal grandmother to be present.
That's already, what to be present, where
Be present in the months. For 3 weeks, mother to be present, and the next 3 months, 3 weeks for
the
the.
father is ready for that, and that's what is the report.
Lord, let the father.
No, whatever, now they'll be both of them on 22nd. They'll appear before the NIMHANS. Whatever the NIMHANS doctor says,
See,
that's why I said,
let that be
whatever the
recorded.
doctor says, they have to follow.
Let father also be present, because the earlier portion of the order says the mother and the paternal grandmother to be present. Let it.
No,
also be
whatever is. As per the advice of the hospital authorities, if the father, mother, grandmother, whomsoever presence is required, they should be present there as per their
Great.
instructions. Yes. Next. What are the other matters?
Hmm.
24, 1 minute. No, I'll call the matters. 24.
Appearing for the petitioner, my lord,
Ah.
serial number 24. My lord, it is with regard to furnishing of the assets and liabilities of the husband and wife. My lord, it's almost ready, my lord. 60% is ready. There are some details which needs to be taken by the client, my lord. For that, we require some
80% for the
time.
next adjournment, 100% after
No,
that.
my lord, next,
When?
next date, 100%.
And when is the date?
My lord, at least it may be given on 22nd, my lord. It's
Given on?
possible. 22nd if possible.
No, you have done 60% or 40%. Why do you want 2 weeks? Next week, post this matter on 16th at the request of land counsel to the petitioner.
Petition.
No further adjournments will be granted. Next, 25.
Not so
I appear for
pleasant.
the petition, my
For
lord.
the appellant respondent, my lord, I filed the wakalat in the
My
morning.
lords, if I may
Kindly show the
be
my name.
permitted to make a submission. This is a case wherein the child wants to go to the father, but the mother doesn't want the child to go to the father. Some really lovely
But
videos of the father.
No,
As per the
let's,
trial court
no, he
order.
says he has the permission. No, he has instructions to file wakalat.
My lords, he's already on record. His name is reflecting
But
online.
25, only
In the
your name
case
is there.
status, online case, I just now saw in the case status, his name is reflecting P. Madhav Swami, if I'm not wrong. It's not reflecting the cost.
First is 25.
Today I
please,
have filed the
25.
wakalat.
Today we have
Please,
filed.
Today I have filed the wakalat.
You know,
Is
we'll
it-
have it, today is Wednesday, we'll have it on Monday, post on 15th. By that time, get instructions,
Yes, ma'am.
get instructions.
Please, ma'am.
Yes,
Oblige.
show the name of so-and-so.
P. Madhav.
Yes,
Grateful,
next, 27. Report from NIMHANS.
Yes, sir. I am appearing for the respondent.
Ah.
Wife has been examined in compliance with the previous order passed by my lordship. Husband is not yet received the call. He was present before the Nimans on 6th, my lord. They have taken his number also, my lord.
The husband shall be present before the NIMHANS on
My lord,
16th. 16th.
okay.
Why? Any
Please.
difficulty?
No, I have no difficulty, but I am awaiting for their call only.
They will call now.
Yeah, please,
16th.
please.
Why then when if it is done for the mother as for to the wife, it
At
should
the
have
ti-
been done to him
Because the
also.
file was to be referred to the doctor by the director. Director was not present.
Post on 16th, the father shall appear before the NIMHANS. Earlier, this court had passed an order on
On 4/7/2020.
4/7,
2024.
4/7/2024. It appears that the wife is examined. For the husband,
he shall appear on 16th and the Registrar Judicial is directed to communicate this order and the report shall be placed before this court by 19th, post this matter on 22nd.
My lord, interim order may kindly be extended.
Interim order earlier granted is extended till then.
My
Yes,
name may
please.
kindly be shown in the cost.
You have not
I have
filed the wakalat.
I filed the wakalat.
So and so submits that he has filed
Nityanand
wakalat.
Nayak.
The registry is directed to show his name. Next. 29. Is GMFC 24 matter post on Tuesday? Yes. 30.
My lord, I am appearing at serial number 30. I am for petitioner. I have some urgency, my lord. Any date may be fixed in the next week, my lord. My lord may fix any date in the next week.
On 18th, at the request of learned counsel for the petitioner. Next, 31.
31, I appeal for the petition, my lord. It's only a petition mandamus, my lord. I've sort of speedy disposed of my petition. It's been pending for
Which
5
year
and a
is
half
the
years.
MC?
2019, my lord.
2019 MC to be disposed of as expeditiously as possible, not later than 6 months.
Please, oblige.
Yes, 32. In all that, notice the respondent is not necessary as disposal is in the interest of both the parties. Next, 32. 32 is 2024 MC. Post this matter on 18th. Next, 33.
Plus 33 appear on behalf of the petitioner. Husband's petition challenging order on IA number 3, that is under section 24. I earn about 1 lakh. Order is at 1 lakh. And order is passed without hearing any of the parties. Kindly,
Parties are not heard.
parties are not heard. Page number 61 of the petition, my lords.
How much
Short
is that
question,
paid
my
now?
lords. 1 lakh,
What is your income?
1 lakh. I have
How
attached
much-
the
how much
salary
you'll-
slip.
How much you'll pay now?
My lords, I have not been heard. Order is at 1 lakh. I earn 1 lakh.
If you want this order to be stayed,
Please,
there should be something.
Lords, I'll
So you have, your income is 1 lakh.
please.
How much you will pay now?
My lords, one submission. I used to stay in the house with my wife. My wife has thrown me out of my own house. Now I'm in a rented house.
Pay 30,000. How much is, how much he asked for?
Sorry, my lords.
So if you want interim order,
Please.
you have to pay some amount.
Please.
Or else if you want to take notice and
Lords, I'll
come back.
deposit 1 lakh.
Huh?
I'll deposit 1 lakh.
It is not like 1 lakh. 30,
My lords, the order is
30,000 per month.
per month. That would be difficult, my lords.
No, why, what are your expenditure? 1 lakh is your income.
Please.
Hmm.
I have to pay rent for the house. I am
How
staying. in.
much?
40,000, my lords. I have 2 children. One daughter is with the wife. Son is with me. I have to take care of their expenses.
Hmm.
And now my wife is also working. All the documents have been annexed. She's working with TCS.
Hmm.
She has a salary in her assets and liability. She says that she has a salary of
The
40,000.
petition filed.
Petition is filed in 2020, my lords. She has not filed objections to my petition.
No, she says that she's earning.
She's earning. She's earning.
No, it is,
It is
what
admitted
are
that
her
she's earning.
statement of assets and liability?
She says she's earning 40,000.
She's getting 40,000.
Yes, my lords.
And you're taking care of one son.
I'm taking care of both. Only son is with me. Daughter's educational expenses. I'm paying the school fees, her uniform, her tuition fees. That is what I'm taking care of.
Hmm.
She's not in my custody. Son is with my
Counsel,
custody.
No, please calculate from the day for what is, you said which month?
Order is on September 25, 9, 2023.
No, not order.
The application, my lords. Because the application is on 19/11/2022.
1911,
2022.
22.
2.
23, 12 months. And this plus 8. 18 months.
Please, my lord.
Learned counsel, the petitioner submits that the wife is working in TCS and the petitioner is getting salary of 1 lakh. Is taking care of the educational expenses of both the children. But the court, without any basis and without recording any reasons, had granted, without hearing, had granted maintenance of an amount of rupees 1 lakh.
1 lakh, that is all.
1 lakh. It is submitted that it's very difficult when he is getting the income of 1 lakh itself. He is not in a position to pay, considering the submissions. There shall be stay of all further proceedings on the condition that he continues to deposit an amount of rupees 10,000 per month. And arrears at rupees 2 lakh, 1 lakh 80,000. 12 plus 8 is 20. At 2 lakh, arrears at 2 lakhs. Arrears of 2 lakhs shall be paid. They shall be stay of all further proceedings on the condition that he shall continue to pay 10,000 by 10th of every succeeding month. And arrears for 20 months, that is at 2 lakhs, shall be paid within 4 weeks from the date of receipt of the copy of the order. Either of it not complied with, the stay granted by this court stands vacated automatically. The petitioner shall take out notice on the counsel appearing before the court below and file a memo to that effect by 9th of August. Post this matter on 13th. Yes, next.
Let's pay to the respondent, my lords. Directly, I shall do RTGS or NEFT transfer.
The respondents.
Please.
So 34, 35, 36,
Flesh.
post it tomorrow.
35, 13th, my lord.
Huh?
35, 13th maybe.
90, these 3 matters, they will not be adjourned. They are under part third. This will be the top of the list along with other matters I said.
13th, I request 13th, my lord.
Day after tomorrow, I inform the respondent.
Day after tomorrow. Which matter is day after tomorrow? 34, day after tomorrow.
35.
35, day after tomorrow, day after tomorrow is Friday. Friday, it is not possible. These 2 matters on Tuesday, 35 and 36.
36 tomorrow, my lord.
36 tomorrow, 35 day after tomorrow,
Great for me.
Monday.
Monday.
Yes, next. All these, where is the list? Dismissal matters shall come tomorrow.
Serial number
Serial number
All the
47.
dismissal matters shall come tomorrow in the list.
serial-
No, tomorrow, all that wherever top of the list I have mentioned, those come. Then the dismissal should come. Then the remaining matters of other days should come.
My lord.
My lord, serial number 47.
44.
Dismissal, filing and retirement memo.
Serial number 39, my lords, 39.1, my lords, wherein I have got an interim order. But last occasion, my lords, non-mentioning of extension, if not has been extended. Kindly be, my lords, serial number 39.1, my lords. Earlier occasion, my lords, before vacation, for 25/4, my lords, it's got.
Why extension of interim order? We'll hear it tomorrow.
Yes, ma'am.
Tomorrow,
It might
post
be-
this matters tomorrow.
Yes.
My lord,
My lord,
serial number
serial number-
Matters are coming tomorrow.
44.
My lord, serial number 40.
Tomorrow. Already there. So then, all this,
39.1.
1 minute, 1 minute.
Yes,
Now, when it is not extended on the last occasion, it will not be extended now.
My lords,
When my
only
hearing big
reason we have
group,
not mentioned, my lords,
37 to 41,
inadvertently. my-
31, but we can't help it. 31 to
Tomorrow, my lords.
41 shall come on Tuesday. Tuesday, how many matters are there? On that day. Then for orders matter, for passing a 42 also on that day.
My lord,
Serial number
44.
47.
Item number 42, my lord. They had sought an adjournment on the last day. They have not come.
Tomorrow, post this matter tomorrow,
My
42.
lord, serial number
My lord, serial
44,
number
44, my
47.
lord. 44, respondent, contested respondent is no more. He has to file date of death. That is the memo he has failed to file it. And you will not see list it
Serial number 47.
next week, my lord.
Yeah, filing and retirement memo can be taken.
You have to file it in section, file it. No, even if you file a retirement memo also, no, when was it informed to your client?
The last month, I think.
So that those details are there. Your client is aware that she has taken the file or he or taken the file.
Yes, madam.
It's their duty to file the wakalat. If they don't file the wakalat, we'll record it and we'll hear the matter. First,
I'll file it.
happily in 2017 matters, whenever the matter comes, then every day I'm seeing that in 17 and 16, giving up wakalat, saying that will inform. Then once you give up the wakalat, because the party knows they have taken it, they should engage. If they're not engaging, court will not issue notice. What are you saying?
44, my lord.
Huh.
Respondent, contested respondent, he died. He is supposed to file a date of the death. He is not filing. That is the matter was set to filing the memo of death, mentioning date.
No, but the difficulty is if the matter is not heard, he will never come and file. This is a 2017
It is
petition.
true, my lord, I'm not disputing with, because he is a contesting matter. If the other respondent was there, I would not cared about it. Because on the order of the Tahsildar, the district judge has remanded the matter to the, again to the Tahsildar without any merit. That is the dispute.
That is true,
Yes,
but
madam.
why should we adjourn it? That's what I'm asking you.
Well,
If he comes on that day, we'll ask him,
If he did, the third, fourth time he is not coming.
delete this matter from dismissal, but let it be there in the list. Yes.
Date mechanism. Date
Tomorrow it will come.
Kindly,
Let it be,
Lord.
so that he'll come, he'll
Yes.
come and, yes.
Serial number 40, my
All
lord.
dismissal matters will come.
Lord, serial number 40 may be taken up on Monday or 18th, my lord. 16th, some inconvenience. my lord.
Serial number 41, interim order may be extended to use.
40?
41.
40, in all the matters, wherever there is interim order, it will be extended. If it is not there on the last occasion, it will not be.
Lord,
What are you saying, Mr. Counsel?
40, my lord. 40 may be taken up on 15th or 18th, my lord.
Tomorrow it will come?
Please, my lord. No,
Yes.
please. Obliged.
And,
My lord's 45.
and this,
Number 51, my lord, full time.
1 minute, all dismissal will come. And these orders matters, sir. All these orders and final hearing, give some long date, somewhere around 29th, Monday. All these matters on 29th. Final hearing also till. Yes,
Serial number
45,
51,
my
full time,
lord.
my lord.
Huh?
Dismissal 45.
it's coming tomorrow.
No, maybe Monday or Tuesday, something like that.
Why?
No, because my counsel will be coming, senior colleague.
You have so many times asked for adjournment in this, I
No,
request. No, earlier also you asked, I
No,
refused
today,
it.
the day I was not present. Monday I was not available.
Let
I was
it
not
be,
visible.
please
Otherwise,
understand, the
oh.
whole endeavor of the court is to see that something is done.
Okay, my lord,
If
then
you
they,
want adjournment, I'll adjourn all the lists and happily sit in the chamber.
no,
No
no,
work to do.
sorry.
That's good for me.
No, it may be dismissed, keeping, only the substitute service will be dismissed. 45, it is for the substitute service, 45.
45, an application is filed for substituted service
Yeah,
for affixing the same on the door of the respondent.
No,
That
that
such an IA is not maintainable. IA 1 of 23 is dismissed. The petitioner is directed to take out notice on the counsel appearing before the court below. Who has to be served now?
no, the councils, because they are appearing for MFA in 2040. The councils are appearing for MFA for the same respondent.
Are printed now.
Yes, yes,
Delete from the caption for dismissal, but let it be there in the list.
yes,
2017 will not go out of the list.
yes. Much obliged, my lord.
Serial number 46 tomorrow, my lord.
40,
46,
dismissal will come tomorrow.
very well.
Yes. Madam. 39.
35 hours.
Madam, 39 tomorrow ಆಯ್ತಾ? Madam, 39 tomorrow.
35. 35.
Ma'am, 15, ma'am, 59 ನೋಡಿ.
35.
62, 62, 61, 61, 61 ಇದೆ. 61 ಮೇಡಮ್. ಮೇಡಮ್ 61 ಏನಿದೆ ನೋಡಿ.
Ma'am, 59. Ma'am, 59.
Madam, 61.
It is 59, ma'am.
Madam, 60, ma'am.
Interim
60.
order extend ಆಗ್ಬೇಕು. Ma'am, interim order. Ma'am, next week I'll date 18th. Okay.
Thirty-five, 15, 7, madam. 22, 7. ಮೇಡಮ್ ನೀವು ಅವಾಗ 35, 22, 7 ಅಂತ ಹೇಳಿದ್ರಿ. ಓಕೆ ಅಲ್ಲ ನೀವು ಹೇಳಿದಕ್ಕೆ ಅದಕ್ಕೆ ನಾನು ಮಾಡಿದೆ.
Final hearing 30, 15. Thank you. Final hearing.